Okay, I think
Okay, we're live. Good morning. This is the Board of Standards and Appeals Public Review Session for July 18th, 2022. There is no public testimony during the review session. We'll begin with the adjournments. The following items are adjourned. Item number 1, 519-57BZ, 2071 Victory Boulevard, Staten Island. Item number 2, 914-86BZ, 19 Eastern Parkway, Brooklyn. Item number 3.
just 1 second on that one. This is the third adjournment, but I know that there's a lot of difficulties with the ownership. We should make a note, though, that it's the third adjournment. I don't think it's appropriate to send them a warning letter, but in setting this on the calendar, we should give them really a long time till the next one. And maybe, I think that the applicant said that they could submit by September, but I think that's putting too much pressure on them. So maybe see if like a January hearing would give them enough time to really regroup. Maybe that's too much time. I don't know, but
December date, maybe?
Yeah, December, check with them, because I know, to make a promise and then it adjourns again, it's really not necessary to put them under so much pressure.
Okay.
I agree with you, Madam Chair. I think long adjournment makes sense. Yeah.
Okay.
Okay. Move on?
Yeah.
Okay, so item number 3, 7211BZ, 10106 Astoria Boulevard, Queens. Item number 4, 2019-264BZ, 3568 Nostrand Avenue, Brooklyn. Item number 5, 2021-9BZ.
Oops, what was that?
Happened?
Cloud recording.
Did we miss the beginning?
The beginning, but you could go ahead though, because it's already on YouTube.
Do we have to restart?
No, you could go ahead.
You sure now?
This is backup recording, but it's already on YouTube.
Oh, it's backup recording.
Yeah.
Okay.
Thanks, Steve.
Item number 5, 2021-9BZ, 145-163 Wolcott Street, Brooklyn. Deferrals. Item number 6, 201-97BZ, 11902 Rockaway Boulevard, Queens. Postponements are item number 7, 2019-96.
Oh, there's another deferral. There's 2019-255A.
Oh, right. Sorry, I thought we were going to do that during decisions. Item number 19, 2019-255A, 621 Alonzo Road, Queens.
And with that one, I want to say again, this is the third, this will be the fourth deferral. So I would say send them a dismissal warning letter, but give them a lot of time and check with them how much time they need, because I know that they're working now with DEP, right? They met with them today.
They're meeting with them again today.
But so check with the applicant, how much time is a reasonable amount of time, because it just doesn't look good to have so many deferrals. And 3 months, we did it 3 months between, so maybe 6 months between is a better amount. I don't know, I have no idea what's wrong. And also, if the applicant is listening, BSA is happy to work as kind of an intermediary with DEP to find out what the issue is and to see if it can negotiate sort of a conditional approval. I know that hasn't worked out so far, but maybe they can be persuaded, because we closed this, it'll be a year in September.
I know.
So, okay.
Okay. Postponements. Item number 7, 2019-96A through 2019-155A. This is Blue Belt Loop, Cole Street, Staten Island. And the other postponement is item number 34, 2022-2A, 728 Court Street, Brooklyn. That is item number 34 on the calendar. And we get to decisions. Oh, shoot. Withdrawal case, item number 25, 2020-65BZ, 1215 to 1217 East 22nd Street, Brooklyn.
And there's another withdrawal, but maybe we read it after because it's not in order in the calendar.
Which one is that?
That's Lyra's case, right?
That's the one I just answered. I just
Oh, then the
announced.
other one is the vested rights, which we can do at the same time. Is
Yeah,
the
can we?
common law
Yeah.
vested case. Yeah.
Yeah.
Okay, we
Okay.
can do it. Okay.
Okay. So do you want to vote?
So withdrawal, when we get to withdrawal, we'll vote on it because we can't read it, right?
Okay. So on 2020-65 BZ, which is Lyra Altman's case, East 22nd Street, you want to do the vote?
Yeah, we can do that. So for a motion to withdraw,
Chair Perlmutter,
aye.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta. You repeat that?
Aye.
Thank you. Commissioner Shabeta.
Aye.
Thank you. Application has been withdrawn. Okay, now on to decision items. Item number 85353 BZ 2402-16 Knack Street, Brooklyn.
Okay, there was no submission required. And so I'd like to make a motion to grant on condition. Yeah, okay. I'd like to make a motion on condition that the site be maintained graffiti-free, that lumen levels are kept off adjacent residential property lines, to maintain the masonry trash enclosure with steel doors and corrugated metal roof, that the signage shall comply with the C2 regulations, no parking on the sidewalk, maintain asphalt and striping, maintain landscaping and planters. And then there's a BP territory manager that's mentioned in the operational plan. That manager must go to the site weekly to monitor site compliance with terms of the grant, and also provide monthly rodent control, and any other terms of the operational plan should be incorporated into the resolution. So based on that, a motion to grant.
Chair Perlmutter,
Aye.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta. Can't hear you.
No, you're muted completely, or something's blocking your audio.
Now?
Yes.
Yes, good, thank you.
Aye.
Thank you, sir. Commissioner Shabeta,
Aye.
application is granted. Item number 9, 43361 BZ, 1702-1712 East 16th Street, Brooklyn.
There was no submission for this and there are no conditions. A motion to grant.
Chair Perlmutter,
Aye.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Shabeta.
Aye.
Application is granted. Item number 10, apologize. 43574 BZ, 552 Midland Avenue, Staten Island.
Okay, so this is something up for a little bit of discussion and a recommendation. The applicant requested removal of the term at the last hearing, and we discussed this back and forth a bit. Proposals were to increase the term to 20 years, which seems to be, after discussion with council, probably the most prudent thing, because and also with executive director Carlo, and with concern about the future changes in conditions that might affect the neighbors, and might for example, might render the variance no longer appropriate, like to not speak for a board in 50 years or whatever, something like that. And also the issue of opening the floodgates to eliminations of terms, whether or not that's actually a good idea. And you would need really clear conditions to protect the neighborhood if you did eliminate the term. So, but I would say in terms of a 20-year, which is what I'm suggesting, and people were kind of like 20 years or remove the term. It sort of depended when we talked the last time. So I'd like to make a recommendation of a 20-year term with the condition that there's no change of use at all. So staying within the use group itself wouldn't be appropriate. So because, you know, obviously the use group has a big range, and it could be like a catering facility, which is a much more aggressive use than this facility, right? So it needs to come, so the applicant would need to come back to the board for any change in use from this specific approved use. There's also, and then as an aside, this is an operational plan there's an operational plan in the statement of facts that was submitted on May 6, 22, that should be incorporated into the resolution. The dumpster needs to be stored inside at all times. No use, but that's what they're representing, they're doing, and they have a place for it. No use associated with this application on the subject site may be conducted on adjacent lot 17, for which no commercial use variance has been granted, and no exterior light fixtures may shed light onto neighbors if and when installed, because they're showing that there are none at the moment installed. Okay, and those are my comments. So that's a motion to grant on those conditions with a 20-year term. And if you feel differently, please say so as we vote. So motion to grant on conditions.
Chair Promoter,
Aye.
Vice Chair Chanda,
I agree with your terms, with the terms you proposed, Madam Chair. I say yes.
Okay.
Commissioner Otley Brown,
I also agree with both the chair and the vice chair. Aye.
thank you. Commissioner Shetta,
Thank you. I'm fine with 20-year term, and I'm even fine with longer if possible, like 30 years or 40 years. I'm open to that.
Mhm.
right?
Okay.
So you agree with?
So
the
we're gonna,
vote?
but you agree, right?
Yes, I said I'm
okay.
fine with it. I agree on the 20-year, and even if it's more than that, I would be fine with it.
Okay, but now you have to vote on the proposal.
I on the 20-year term.
Thank you.
Commissioner Shabeta,
It's in the fine print.
Thank you. I agree with the 20-year term. I also visited the site. I did not see the dumpster outside, so it wasn't on the interior. And I have no objections to this, so all right.
thank you, sir.
Thank you.
Application has been granted. Item number 11, 1254 80BZ, 511 Avenue R, Brooklyn.
Sorry, scrolling. Okay, we didn't have any submission, and just as something to clear up, we have air quality sign off and LPC archaeological sign off or whatever sign off. So we're good. Those were open issues before, so we're good. So motion to grant, and I don't see any conditions.
Chair Promoter,
Aye.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Shetta,
Aye.
Commissioner Shabeta. Could you repeat that, sir?
Aye.
Thank you.
Commissioner Shabeta, there's something really strange with your mic. I don't know if there's anything you can do about it. I'm just not sure whether the transcript, when you say sentences, will have any problem translating. You know how YouTube basically transcribes the language, and whether there's too much interference for you to be understood. I don't know.
I just turned on my backup mic. This is an external microphone. Is this better for you?
Yeah,
It's a lot of-
can I make a suggestion, Commissioner? Lower, if you're using that microphone, the standalone microphone, just turn down the volume on the front that big knob. Just a little bit. You're just over distorting. That's what's happening.
Is this better?
Much better.
Great.
It still has a little vibration at the end, but it's
Maybe a little lower, just a little bit more.
Okay,
still.
satisfied?
Yeah, it's
That's fine.
actually very loud. Maybe more, bring it down significantly and then let's try it again.
Okay, this is,
Oh, that's good. That's good.
keep this then.
Yeah,
Good.
You sounded too powerful.
that's it.
Okay,
Like Oz.
great and powerful odds, right?
Right. Okay, go
To
ahead.
continue with decisions, item number 12, 75884 BZ, 1444 Clove Road, Staten Island.
Okay. Sorry. All right. So applicant submitted photos and drawings showing the planting, fencing, signage, and trash enclosure installed. This one, we agreed that because of the use, it's only a use group 6B. So there isn't anything more aggressive than an office that could go there. So we had talked about removing the term for this use group 6B use, and it has to stay as a use group 6B use and maintain the landscaping and the trash enclosure. It's sort of a decorative residential trash enclosure, and keep the signage at this kind of minimal type of signage that's representative of a doctor's office or a law firm, which is this one. So obviously they don't need to have a law firm always. It could be a doctor's office, I guess, if that complies with zoning, because the doctor's offices are limited, I believe, in this area to a maximum size. So anyway, if everyone's okay with that, we could remove the term. So again, I'd like to make a motion, and again, no changes from use group 6B, or they have to come back to the BSA. Okay, so for a motion to grant on those terms and conditions, and if you don't agree, or you want to do something else, let me know. Okay, go ahead.
Chair Perlmutter,
Aye.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Shabeta.
Aye.
Thank you. Application has been granted. Item number 13, step 17197 BZ, 6501 Casina Boulevard, Queens.
Okay. So at the last hearing, we asked that the use groups be shown on the plans, use group 6 and 9B, use group 6B and 9 trade school to be shown on the second floor, and use group 6 retail and conforming uses, which in this case is use group 3, shown on the first floor, which they did do. And we also asked that the size of the trash enclosure area be significantly reduced. The drawings show it not extending past the property line, but it's still long. So, and I understand that there wasn't time for the applicant and the applicant's representative and the owner to dig fully into our recommendations. So what I would like to do is, and they make a representation in the letter they submitted, that they're going to continue to look into these. So I would like to add a condition that they would investigate, as we requested, installing a small compactor in the restaurant. So that would reduce the amount of trash that's ends up on that street enclosure. I'll get to you anyway. And then reduce the width of the enclosure area. So they said that instead of that very long thing in the what do you call it, the chain link fence, they were going to remove one of the dumpsters and so shorten the width. They could do that if they had the trash compactor in the restaurant. And that they were also talking about switching to a sliding gate. So these are, in a sense, recommendations that they continue to look into this. It's not a condition of grant, but it's not a condition that they do it. It's a condition that they continue to look into improving the situation. And these are some of the ideas. They were going to also look into better rodent-proof enclosures, which we had discussed, and you'll see in the folder. There's this Brooklyn-produced trash enclosure that's tested out really well as an rodent-proof enclosure system. I forget what it's called now, in city or something like that. And then I discussed the use groups. So that's my recommendation. And so I'd like to make a motion to grant on that recommendation, but of course I see Vice Chair Shonda's hand up, so go ahead.
The applicant had submitted a revised plan in that it did show that the trash enclosure was within the property line.
I know.
Oh, okay.
That's what I said.
Okay.
But it was only, so what we had said was it's supposed to be in the property line. That was what was approved previously.
Mhm.
It wasn't built like that, right? So they're showing it the way it was approved previously, but it's really long and it fits 3 dumpsters. And the discussion was maybe three dumpsters is a lot to put on the street like that. Maybe you can reduce it by having a compactor in the restaurant where all the trash goes in and gets squished into these little blocks, and then you put it into the dumpsters. And then the other was that they liked the idea of this rodent-proof trash enclosure, which doesn't really need fencing around it, right? But they're not cheap. So, and I've heard great reports on them, but they're not cheap. So it's a major investment, and I get it. It's a major investment. So, okay. So, okay, go ahead.
I would put it as a condition and something that they can look into for within the next, I would say, give them enough time to address those, like 3-4 years or so.
It's okay. It's just a condition to investigate. It's not a condition to do it, right? I don't know what else. You want to put it in as a condition to actually?
No, I agree with you, because I think the most important part for me was to make sure that the trash enclosure was not encroaching onto the city sidewalk.
Right.
And that has been addressed through the plan, and hopefully that will be carried forward in reality. And what happens behind that is to reduce the footprint of it. And I think your recommendation is fine.
Okay. So then it was a motion to grant on conditions. So we need a vote.
Commissioner Sheta has his hand up, and so does General Counsel. Oh.
Okay, so let's just go around. All right, so Commissioner Sheta, you have a question?
Thank you, Tony. What is the reason for the investigation of that refrigerated trash item?
So we talked about this at the last hearing, which was whatever. When was that? In May, end of May. And during that time, the applicant's representative started looking into our recommendations, right? So they looked into, and none of these things are cheap solutions, and I understand it, and it's related to the restaurant, right? So the little trash compactor thing costs whatever it costs, but it would be restaurant scale, not what you might put for, I don't know, a daycare center. Maybe we've seen them on daycare centers, but maybe that's juice boxes and not much, right? Not pizza boxes, right?
Are we asking for this just to minimize the amount of trash that they put, then they can control the size of the enclosure outside?
Yes.
That's my understanding, right?
Yes.
So I would make the language bit different, like ask them to investigate this or any other solution that can lead to the objective that we want to achieve. Like do whatever. If we ask them to investigate, and this is my point, if we ask them to investigate something that's gonna cost them too much money, I believe the word investigate is gonna be useless here.
Okay.
We either eliminate it, and we're very generous, or if we want to ask them to do something, ask them to investigate this or anything else to achieve the target. And the target is keep your trash enclosure within your property and make it looks like that in reality, not just on a drawing.
Right, so it's also to reduce the number of dumpsters. They have 3 dumpsters. The goal is to reduce it to 2 because it's this really, really long thing. So that was the other part of it. And then the other thing they were supposed to do was put a sliding gate on it. I don't see why they can't do that because that was the other thing that makes the enclosure so long and wide, because they need both the width of the front to back depth of the dumpster plus like a little walkway in front of the dumpster in order to get to it. But if you had sliding gates, you wouldn't need a walkway. You could just open the
Yes,
gate,
open and take it out. Yeah.
and then close it again.
Yeah.
So that one I think should be a condition of approval, not a suggestion, you know. I agree with you. I think they should investigate they should. So the word investigate. So what do we say about that instead? To
Come up with a solution to make to change the size of the trash enclosure to be within the subject property, and that simple. And it's up to them to do it the way they want to do it.
Okay, that's fair. Okay. Yeah, thank you. And Chase.
Hi, can everyone hear me?
Yeah.
Yes.
I was just going to say that the applicant, it seems that the board wants a condition that the applicant should improve shall maintain the trash enclosure in compliance with the drawings, but shall also improve the enclosure by installing a small compactor, and the rest, improve, including but not limited to installing a compactor, reducing the width of the enclosure by removing 1 dumpster, switching to a sliding gate, better road improving. I wanted to add that all of these modifications may be approved by letter.
Okay. Yeah, that's good. In case DOB has a problem.
Well, some of these might be a modification to the drawings.
Yeah, exactly. Okay, great. All right. Any other comments before we go around to this? Yeah, go ahead.
I did with the language that Chase is using, those sound much more like conditions as opposed to recommendations.
So it's not so the way we recast it is the condition is to improve the situation, to reduce the number of dumpsters by 1, to ensure that the enclosure, the only way that the enclosure can come up to the property line is if they have sliding gates. Otherwise, this doesn't work, right? So what you're doing is you're reducing the size of the enclosure by the width essentially of 1 dumpster plus this access weight.
I just want to confirm that we're not requiring a trash compactor.
No, it's to come up with a solution which could include a compactor, but doesn't have to, and could include rodent-proof whatever enclosures, but whatever.
So maybe language like such as.
There you go, such as. Yeah, such as language. All right. Is that clear, Chase?
Yeah, that's clear. That's Commissioner Shabeta was echoed what my intentions were. Thank you.
Okay. Great, thank you. All right, so let's do that again. All those kind of clarifications on the condition and a motion to grant.
So this is for 17197BZ, 6501 Casino Boulevard, Queens. The motion to approve. Chair Perlmutter.
Aye.
Vice Chair Chanda.
Aye.
Commissioner Otley Brown.
Aye.
Commissioner Shetta.
Aye.
Commissioner Shabeta.
Aye.
Application has been granted. Item number 14, 18098BZ, 163-10 Pigeon Meadow Road, Queens.
One second. Okay. I think we didn't. Oops. Sorry. The little dial is spinning. Okay, I don't think there was a submission. The applicant submitted. And there should be conditions. So I'd like to make a motion to grant on condition that the air vac be turned off during closing time, or let's say after closing, that planting, that landscaping should be planted as shown on the drawings, that no commercial uses or uses accessory to the subject site shall be permitted on lot 7, which is that landscaped area, that the trash shall be stored inside the enclosure, the site maintained graffiti-free, and maintain the site, asphalt, landscaping, etc. in good condition, and signage to comply with C1 regulations. Okay, and they did show more extensive landscaping on lot 7 to eliminate the possibility, I hope, that it becomes an extension or a parking lot for the subject site. Okay, so motion to grant on those conditions.
Chair Perlmutter,
Aye.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Shabeta.
Aye.
Application has been granted. Item number 15, 26803BZ, 14555 Guy Brewer Boulevard, Queens.
Hard to say, right? Sorry. Uh-oh. Yeah. All right, sorry. We received just now the community board's conditional recommendation plan. The applicant then revised the plans to respond to those requests, which include a trash enclosure and like little planters as opposed to in-bed planting, in-ground planting. To the extent that those can be done now, in particular, the signage now is in the next few weeks or a couple of weeks or less. In particular, the signage at the pump islands to alert customers to turn off their radios. We can decide on the application today, but not issue the resolution until proof of installation has been submitted. So, and I'll just read the community board's recommendations, which are reasonable. New planters would be put around the gas station property for beautification of the site. Applicant will work with the community board to maintain existing planters at the corners of the intersection of Farmers and Guy Brewer Boulevard. Existing trash dumpster will be enclosed with a new 6-foot high chain link fence with privacy slats. New site lighting will be put in along the northern lot line by the trash container and car wash machines. Signage will be placed along the pump islands, alerting customers to turn down or turn off their radios. And there will be daily, weekly maintenance cleanup activities around the entire site, especially around the clothesbin, car wash, trash dumpster area. I think those are really reasonable conditions and shows our appreciation for the community board's review of this. So those are the conditions I'd like to recommend. And as I said, whatever can be implemented now in the next week or two should be done now. And then the resolution will be held up until, at the very least, those signs are installed. Okay. So a motion to grant on those conditions.
Chair Perlmutter,
Aye.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Shabeta.
Aye.
Application's been granted. Item number 16, 6-04BZ, 7118, 7124 3rd Avenue, Brooklyn.
Sorry. Okay. I believe the requested changes to the statement of facts were made. There's now no mention at all of the sprinkler system, only that a fire alarm system will be installed. they removed where appropriate reference to the PCE and replaced that with health and fitness establishment. There's still mention of the PCE in the statement of facts, but that's kind of an accurate history of the site. So, but then going forward, that the use is actually health and fitness establishment. We've had many discussions about the elevator. And there isn't any mention of, there is a little description of the history of the elevator and DOB, whatever it is of the elevator. I just thinking that maybe in the resolution, we just say something to the effect of the BSA takes no position on the elevator's placement or legality, and leave it clearly to DOB to work out. And then I just want to make sure that, let's see, our resolution should clarify that the variance is limited to this use as a health and fitness establishment, use group 6, and accessory offices only, as opposed to use group 9, because that opens it up to a whole other range of uses potentially in the future. So use group 6 and accessory offices, this is after all a variance. So those are my recommendations. Motion to grant, and please say what you think if it should be different.
Chair Perlmutter,
Aye.
Vice Chair Chanda,
Aye.
Commissioner Artley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Shabeta.
Aye.
Application has been granted. Item number 17, 120, 13 BZ, 1815 Forest Avenue, Staten Island.
Just one more. Sorry. Okay, we closed this case in April of 21. And the decision has been deferred to allow the applicant time to complete several studies and install certain improvements. There have been submissions since April that I'm just going to go over because we haven't had a hearing on this since then. On June 30th of 21, drawings were submitted that show the addition of an acoustical blanket on a section of the existing chain link fence at the western property line, which was shown in the acoustical studies to need that kind of protection. So that's just a blanket, right? On July 28th, 21, an air quality report was prepared to respond to neighborhood complaints. It employed 6 monitoring stations located along the residential property lines and at the drive-through, with data, air quality data collected over a 24-hour period, which revealed no measurable impact of idling cars and drive-through on air quality. There were momentary like jumps, really momentary, and then went down. So it doesn't look like there is a lingering impact, especially at the residential property lines. We received photos of the acoustical barrier just now being installed. Due to the noise issues that this site presents to neighbors, the attenuation methods called for this heavy duty system that, as you can see from the images, requires the installation of footings to support it. So not acoustical blankets that you just attach to a chain link fence. I need to say that the applicant has demonstrated its willingness to address the community's concerns and has obviously gone to great lengths and expense to accomplish this properly with both environmental studies and changes to the site, costly changes to the site. I appreciate this very much, and I sincerely hope that given these enormous efforts by the business owners, the neighbors appreciate it as well. My notes show, and I think this is something that I think it was Jolene Ebanks-Chu who noted this, that the applicant is requesting a short turnaround. In other words, a short leash, as we often say, to demonstrate that the site has been improved to comply with the drawings. But I'd like to say that the applicant is welcome to come back at any time, but we can have our compliance officer check the sites in, say, 6 months, or say 6 months. And if the applicant chooses to return before the 5-year term expires, because this is a 5-year term for drive-through, right, which is the maximum we're allowed to grant, it can come forward at any time. My understanding is that they would want to request an extension in the hours of operation of the drive-through, provided that the improvements indicate that this would be appropriate. In fact, once the acoustical barriers are up and so on, and the trash enclosure has been relocated, then they could revisit the site conditions and see whether extending the hours, which November 2nd, 2020, were reduced for the drive-through to 7 a.m. to 9 p.m., which is not as long as a lot of drive-throughs operate. So I just think it would be easier on them if they just came back when they thought appropriate, and that this be a grant for 5 years, because they've been at this for so long. Okay. The other thing that we never got, and perhaps they could submit that, we never did receive the updated lumen spread diagram, I don't think, unless we did. And there was some discussion about using transparent material for the fence instead of solid material, but I think that's part of their original submission, there's earlier submissions. So yeah, so those are my recommendations and so on. Okay, so a motion to grant on the condition that they complete the installations as discussed, as their drawings show, which will include, I think that what they tried to do was transparent material for the fence that's along Morningstar Road, so that the height of that acoustical enclosure wouldn't obstruct the view. That was why they were moving towards that. And also that the lighting not extend beyond the property lines, and that all those acoustical measures are installed, and then the trash enclosure is relocated as shown on the drawings. Okay, so a motion to grant on those conditions.
Chair Promoter,
Aye.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Shetta,
Aye.
Commissioner Shabeta.
Aye.
Thank you, sir. Application is granted. Item number 18, 2017-265BZ and 2020-2BZ for property 318, 320 54th Street, Brooklyn.
There was no submission required on this and no conditions, so motion to grant.
Chair Promoter,
Aye.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Shetta.
Aye.
Redo.
Aye.
Thank you. Commissioner Shabeta.
Aye.
Thank you. Application has been granted. Sorry, give me a second. Continuation, item 19, 2019-255A, 621 Alonzo Road has already been deferred. Item number 20, 2021-78A, 131 22nd Street, Brooklyn. And item number 21, 2021-80 BZY, 131 22nd Street, Brooklyn.
So actually, 2021-78A, which is the common law vesting case, is being
Sorry, I should have called them together.
right. So we're going to call that to a motion to withdraw that one. Okay.
Okay,
And go on with the statutory vesting.
Okay, so 2021-78A, 131 22nd Street, Brooklyn is being withdrawn. The motion to approve. Chair Promoter,
Aye.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Oh, we don't hear you. Oh, she's not there. Okay, we can go
Okay.
on. She always said it was called away.
Oh,
So
what's
let's
the-
move on. We have a quorum without her.
Okay. Commissioner Sheta,
Aye.
Commissioner Shabeta.
Aye.
So I'll do absent for Commissioner Otley Brown.
Yeah.
Application is granted. Item number 21 again, 2021 80 BZY, 131 22nd Street, Brooklyn.
Okay,
I'm
so,
sorry, Madam Chair.
yeah,
Just to backtrack a little, Tony, the last application was withdrawn.
that's what we
Yes.
just said.
Yeah,
what did I
you
say,
said it was
granted?
You said it was
Oh, I'm
granted.
sorry, I apologize.
Oh, withdrawn, right. The
Sorry, I just
withdrawal-
wanted to clarify the record. I
Yeah,
apologize.
Sorry, thank you.
It was,
Thank
the
you.
withdrawal was granted. Yeah, right. you're right.
Withdrawal was granted, sorry.
Yeah, yeah.
Thank you, Carlo. I was about to say that. Thank you.
Thank you for your vigilance.
Yeah.
Okay, so as was just stated by a couple of, maybe even three whole people, applicant has withdrawn the common law vested rights application under 2021-80 BZY, and we are now going to vote on the statutory vesting application. I want to clarify the standard for this because I did see some back and forth about foundations over the review period here. To clarify, under section 42-111, which is special to this situation, no demonstration of foundation completion by the amendment date is required. Instead, proof of permit by April 23rd, 2018 is required to continue construction as of right. The permit was issued in 2015, so well in advance of that. However, because no temporary CO issued prior to December 20th, 2021, as required by section 42-111, the applicant must demonstrate to the board that substantial expenditures and construction have been made as of that date pursuant to section 11-332. So that's where we come in, 11-332, okay? Exterior photos taken on October 21st, 21 show a fully enclosed and clad building with fenestration on two facades. The third facade shows steel framework for the fire stair and masonry openings for doors. So clearly, just 1 second, sorry. So clearly the finding for substantial construction is established by that. The applicant was asked to submit to clarify financial expenditures made as of December 20th, 21. We received an accounting of hard costs to date totaling $5.6 million. It includes costs after 12/20/21, in fact, all the way to the current date. But we had seen earlier demonstration of 4 million in costs. And I think if you subtract the 2022 numbers from the list that we just received, you would be at least at 4 million. And soft costs and payments to neighbors for access were not included in this hard cost analysis. So I believe the cost for expenditures also, the finding for expenditures was also made. So that's my opinion, and I'd like to, if you have any different comments, please add them, and I'd like to make a motion to grant.
Motion to grant on 2021 81 BZY, sorry, 80 BZY. Vice Chair,
Wait, no. This is, wait a minute, this is an A case, right?
no.
No. Oh, okay.
We just withdrew the A, remember?
Oh, boy.
We're
Did I
doing
read
the
the
statute,
wrong?
the common law was withdrawn. Now we're doing the statutory, which is 2021 80 BZY. We just withdrew
Okay,
the,
so I made a mistake in my statement, so let's just clarify. Tell me which one. No, so the common law vested rights is 2021-78A,
A.
right? Okay,
We just took a vote on that.
Okay, so 20, so that's the one that was withdrawn, and this one is 2021-80BZY. Okay, sorry.
Correct.
Yeah. Okay, go ahead, sorry.
Okay, so the motion to approve, Chair Perlmutter,
Aye.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
I just want to say I removed the checks and did the math, and you end up with $4.8 million. And so I think that's substantial as well. So aye.
Yeah.
thank you,
Thank you.
Commissioner. Commissioner Sheta,
Aye.
Commissioner Shabeta,
Aye.
application is granted.
Thank you for doing math. Okay. Okay.
Item number 22, 2022-24A, 4074 Victory Boulevard, Staten Island.
Okay. I understand the council member and civic association's concerns about the access to the site. But the application before the BSA is only for a waiver of GCL 36 to allow construction of a school without frontage on a mapped street. These are improved but unmapped CCO streets. The SCA, School Construction Authority, has indicated a willingness to obtain the adjacent parcel if possible to add an access point from Wild Avenue that would allow car drop off. The council member submitted a letter on July 8th, 22, requesting that our decision not fix the design of the project so as to allow continued negotiations. I encourage the council member and civic association to meet with SCA so that all parties can discuss their concerns, and also to help SCA facilitate improvements to the site where such input would be helpful. BSA is always open to project changes if called upon. Again, this is only a GCL 36 waiver to allow construction of a building on an unmapped street that complies with building codes, addresses DOT, fire department, and DEP concerns, and complies with zoning regulations that may not otherwise have been waived by mayoral override. So, and all required sign-offs have been received. I'd like to condition this grant, proposed grant, on complying with school safety and DOT's conditional approval comments, which should be incorporated into our resolution. There's also archaeological investigation requirements, conditions, as outlined in the EAF, which should be included in the resolution, and also fire department conditions that should be incorporated into the resolution. So with that, a motion to grant on those conditions.
Chair Perlmutter.
Aye.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Shabeta.
Aye.
Application has been granted. Item number 23, 2020-74 BZ, 1500 Williams Bridge Road, the Bronx.
Just to note, the calendar date is incorrect on the materials. The case was closed on May 24th, 22. So that should be corrected on the calendar. Applicant made a very detailed and responsive submission that includes better planting bed dimensions and details, improved ADA access to the building by leveling out, changing the degree of slope on the site, which is much better than installing a ramp. Better parking spaces and better oriented and increased parking spaces, a masonry trash enclosure with steel doors, and improved site drainage. I just want to say that I very much appreciate this applicant's responsive to and respect for the board's comments on all of its applications, makes the cases go so much more quickly and efficiently. And I just want to note, because we're always looking for good details, and Jella maintains kind of a detail file, that drawing BSA 002 has a really good planting bed curve detail that you could be showing to applicants who don't know how to do that detail. Okay, so my motion to grant no conditions.
Chair Promoter,
Aye.
Vice Chair Chanda,
I want to add that the applicant also reached out to its neighbor who had expressed concern during the hearing and has discussed the matter. And I think the issue was with regards to drainage. So again, I really want to thank the applicant being proactive and working with its neighbor in addressing their concerns too. So with that, I say yay.
thank you. Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Thank you, Chair. I'm not gonna thank the applicant like usual, but I would say that, look at this case. This is the second hearing and it's done. Some other auto service locations take up to probably 6 and 8 hearings, and we get them to the finish line by like pushing the applicants to do so. So that's a good work. I believe all the applicants should be looking at this case and try to get it to the finish line as quick as that one. Thank you, and I vote aye.
Thank you.
Commissioner Shabeta,
Aye.
application granted.
So I just want to add to that, it was actually only one hearing and it closed on the very first hearing.
Yeah.
And for this submission, it responded and made all the corrections or changes requested of it and didn't put, came up with great solutions.
Yeah.
Okay.
Item number 24, 2021-43 BC, 9091 Channel Drive, 9091 Beach Channel Drive, Queens.
Again, on this one, the calendar has a date that's incorrect. The case was closed on June 7th, 2022. So that should be corrected. The site plan was modified to much improve the relationship to the adjacent residential neighbor with dense landscaping and the relocation of the trash enclosure, which allowed for an additional parking space. So kind of a win-win. So I do very much appreciate again this applicant's responsiveness, and I know how pressed they are time-wise. So cooperation in both directions results in a short hearing schedule. So, okay, so I'd like to make a motion to grant on condition. So with respect to lighting, that no lighting in the parking lot shall shed on adjacent residential properties, on obtaining that they obtain modification from EDC of the restrictive declaration to allow the proposed use, because obviously that prevents the proposed use if they don't get that modification, that they need to meet the trip generation rates that are shown in their analysis. They need to meet them on site and off site. So this is conditioned on provision of off-site parking as they propose to meet trip gen rates, and also conditioned on so DOT has a condition which should be incorporated into our resolution, that they pave the sidewalk all the way around the building, all the way around the building. And then to just add, unless the applicant obtains from DOT an approval for an alternate solution. So those are my recommendations or conditions that I'm proposing. Commissioner Shetta.
Thank you, Chair. Yeah, regarding the condition on the lighting, I want to thank them for adding this note to the plans, but because of some like confusion in the language, when I read that note on the plans, I was confused. There was like some sort of mix up between the noise and the light. So I would like to make the condition on the noise and the lighting. So I would like add in the resolution a condition like the construction and the use of the parking lot should not result in like any noise or lighting that imposed on the adjacent residential property. Just to make him both, and instead of just lighting, make him lighting and noise.
So what kind of noise are we talking about? like, I guess, are we talking about that? I think they put up acoustical, didn't they put up acoustical fencing? In that, I think that's there, right? Don't the drawings show acoustical blankets on that fence?
I don't believe so, but I can take a look.
Okay, so we could say installing acoustical blankets on the fence. I thought that's what we said. Now I can't remember. To shield applicant from a noise cars. I'm just looking to see whether does anybody remember this?
I don't.
I'm looking at the site plan. The notes.
I can share the site plan if you want.
Oh, I see. I saw noise attenuation accepted based on memo and previous analysis. That was in the seeker notes from before. And I can't think of where else there would be noise attenuation.
Jella's hand is up.
Yeah, go ahead, Jella.
think it was the conversion of the building, the enlargement that occurred. They had built in some sound attenuation according to the seeker requirements that they had. And we accepted that for this use as well.
Okay, so to not complicate matters, how about we say if there are noise complaints from the adjacent residents, that they install acoustical blankets on the chain link fence?
I'm fine with language like that. Yeah, that's fine.
Okay. Acoustical.
Or otherwise address the noise complaints, right?
Right, yeah.
Thank you.
Okay, that's a good idea. Thank you. All right. So let's go back to the vote with those conditions, modified conditions.
So we are voting on 2021-43 BZ, 90-91 Beach Channel Drive, Queens. Chair Promoter,
Aye.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Shabeta.
Aye.
Application has been granted. Okay, and as we stated before, item number 25, 2020-65 BZ, 1215, 1217 East 22nd Street, Brooklyn, has been withdrawn.
Right. Could we take like a 3-minute break? Sorry, 3-minute break. That's all. 11:03 back at 11:06. Sorry. Apologies, everyone. I'm back.
Okay. We are now on SO Special Order Calendar, continued hearing items, item number 26, 1069, 27 BC, 6702, 6724 New York Avenue, Brooklyn.
Okay. Wait. Let's see. With respect to the curb, I'm just sort of jumping right in. With respect to the curb cut on Ovington, that is in photographs and drawings shown as blocked by planters, there is a proposal submitted from a contractor to remove it. So it's a costing proposal to remove it essentially. So that's a good thing because that's what needs to be done. Maneuverability plan was provided to show the curb cuts to remain are adequate to avoid driving on the sidewalk, which is what we were trying to avoid. And the vacuum is located both at the interior. So there's one type of vacuum on the interior and another one that's on wheels. So it's not fixed according to statement of facts. So there's less concern about an exterior vacuum and what that would do on the site. So I'd like to make a motion. Oh, sorry, I can't make a motion. But so one of the conditions is, of course, the removal of a curb cut, storage of trash dumpster inside during off hours, and no installation of a fixed vacuum on the outside. Okay.
This is a continuing hearing, so I do have no comments on it.
Yeah, I'm just sorry, I was typing and I didn't get there. No, it's not the vacuum on the outside. Yeah, sure. Okay, Vice Chair.
Okay, thank you. I unfortunately was not able to locate the maneuverability plan that you're referring to. So I think a lot of.
Can I just tell you what it is? I wasn't either until I looked back at the drawing that they referred to. It basically doesn't have lines that show you how the cars move. It's just the cars in spots, and you have to do your own visual line attachment. I didn't realize because it's labeled maneuverability diagram. So when I saw that, then okay, we're supposed to make the connection. Which is not.
Well, okay, so that's the same one I saw. And yes, I think the applicant should have been given a sample going forward to do that. I agree the curb cut is wide enough to allow for a vehicle coming on to that portion along U-track where the extra cleanup and all of that or special detailing that is happening then for the vehicle to use the curb cut on Ovington and then turn into the building for cleanup. So, and I hope that is what the practice is. So I'm okay with that. I was not quite satisfied with the document that was submitted with regards to the removal of the curb cut. Now, the applicant has provided a letter from the contract, but it is not a signed contract, and this is something that the board had asked since 2002, and the curb cut still remains in place. Also, I think we need to be mindful that the applicant is requesting an extension of term for 19 years, technically 20 years. And so I would be uncomfortable granting such a long extension with a task that has been pending since 2002 and giving such a long extension. I think prior to granting that, the applicant should make these improvements and there should be a time clock put on the CO. I think the CO needs to be renewed and the CO term should be 2 years or so. within 2 years, the CO should be issued. No, Madam
I'm sorry,
Am I-
Madam Vice Chair. I'm sorry. I just want to be clear. Has everyone seen the July 15th submission from the applicant?
yeah.
Okay, I
Yeah.
just want to make sure because I'm listening to some of your
Wait,
Okay.
sorry.
Well,
Is
it
it
was
July
the July 15th.
I'm sorry, go ahead. Go.
The July 15th submission was just a letter, right? That's all I have.
Right, because Carlo and I, we received an email from the applicants because of the items that Vice Chair had asked about. They did send, Daryl, the project manager, had sent a maneuverability plan, and there's some issues. He was going to adjourn, and we said we didn't think it was appropriate to adjourn, to request an adjournment. We said, let's have another discussion because there are several issues and you need to have the feedback from the board. So then they submitted this statement. So I just wanted to make sure you guys saw, all the commissioners saw it.
Yes,
Okay.
so we saw it, but it's not like it's a proposal for this much money to start next week. I think that's really what the issue is. It's more like,
Right, there's like a timeline here and.
no, it's a proposal for a proposal.
Right.
We're supposed to give you a proposal someday. We don't know when. I
Yeah.
understand that.
Yeah, it's a bid. It's not a signed contract.
Yeah.
I think given the amount of time that's been given since 2002, at a minimum, we should have a signed contract with the contractor to build the curb cut out and a timeline, and then have a condition whereby the CO has to be, within 2 years or 3 years, however long it takes to get the CO renewed. That way, should a 20-year grant be given, this way at least we have some commitment from the applicant to get the work done. Also, I think in the plan, though I understand the vacuum cleaner can be rolled in and out, which is great. I did not know that can be done. The applicant should show in the plan where that rolled in and out vacuum cleaner would be located. Again, anybody who is at the site knows this is where the vacuum cleaner would be located and not on a sidewalk or so. I was looking through the applicant's latest letter, in that the applicant talked about, because I had raised this question about the asphalt paving that is on the portion of 15th Avenue sidewalk. And the applicant had indicated that it's not sure when it was put in because it has been there from the prior grant. So when one looks at the Google Street View map, the historical street views, it goes as far as to 2011. And it seems like pretty much 2011 when the fresh patch of asphalt was put in. And I think what had happened was the applicant was going to, let's step back. Applicant typically maintain the curb cuts that facilitate access to their business. So it is safe to assume that all curb cuts facilitating access to the subject site shall and has been maintained by the operator. So when you look at the Google Street View map, it seems that the site at the corner of 15th Avenue and New U-Track was asphalted over, and possibly it was around 2011 because it looks like a very fresh set of asphalt along the curb cut leading up to 15th Avenue. So I am not sure what DOT's maintenance standards and requirements are for such curb cuts. And it was in an attempt to kind of extend the curb cut out from its property onto the street. The applicant asphalted out not only the portion on its property, but up to the sidewalk onto the city street. So I do think it was the applicant, but I think the applicant should talk to DOT and find out maybe DOT did it and have it repaired and fixed, whoever is responsible for it. I also think because the applicant is working with contractors in fixing restoring the curb on U-Track, I think it's the same contractor that also can do the restoring of the sidewalk on 15th Avenue. And again, similar to the restoration of the curb cut, the applicant can be given enough time to do that restoration with the cutoff date of CO issuance.
Can I make thank you. Can I make a suggestion though? Because we've seen so much that let's just say we have a term of 10 years, just to throw out a thing, where there's a CO requirement in 2 years from the date of the grant. And very often they come back in 10 years because DOB catches that. And so they've had 8 years to not have a CO, which is one. So one idea is instead you put this on a short leash. So like a 2-year grant, give them the time to do it, and then they get the 19 or 20-year extension.
I'm fine with either. I'm fine with either. I think the aim is to get the work done, and then either way, I think as the solution outcome is fine. It's for the applicant to give that recommendation to us. I like your suggestion too. Yeah.
Okay. All right. Good. All right then. Commissioner Otley Brown.
I have no additional questions.
Okay. Thank you, Commissioner Sheta.
Thank you, Chair. I want to say that I totally agree with the Vice Chair. We need to take an action. When reading the cover letter for the submission from July 15, I feel some sort of like will do, like that willing thing. I don't like that.
We can't
Losing
hear
your
you.
volume.
No, you need to stay closer to your mic. As you sit back, we can't hear
Now
you.
you're muted. Now you're muted, Vice Chair. Sorry, Commissioner Sheta.
No, we can't. We can't hear you at all. Do a test before you speak, okay? Just say test, test.
Muted.
Yeah, I muted. Do you hear me?
Yes.
Yes.
Okay, thank you. It's the technology, it's not me, trust me. Yeah, like I said, I did feel some sort of like, we'll do it tomorrow, and then when tomorrow comes, we'll do it next week, and when next week comes, we'll do it next. It doesn't work that way. We need to set a date for an action to be taken. I don't think a survey should need 3 months to be done. That's too much. The survey usually is done in 1 day. Probably you need a week to retain a surveyor, and then it's 1 day in the office to be finalized. That ask for the permission for the applicant's office to do the survey. I'm not sure if that should have been presented to us. We do not grant a land surveyor licenses here. If you need a surveyor, you need a surveyor. Hire one, get it done. I don't think it should be 3 months. I believe you need to act on this like in a timely manner so we can proceed. So I'm totally in agreement with Vice Chair on this case. Thank you.
Thank you. But do you have an opinion about whether we do CO or, well, anyway, we don't need to decide this now. In fact, this would be a conversation with council and Carlos, so for the technical aspects of it. So, okay. Okay, and Commissioner Shabeta, no, I didn't forget you. I was writing and I can't write and talk at the same time, though I should be able to. I can't.
Thank you, Chair. I agree with the statements that were made by you and yourself and the Vice Chair. I was thinking about making, I was agreeing with the 2-year term. I was thinking that would be great if we can offer an extended term after that with the assurance that if everything is positive after the 2-year term on return, they can have a longer term than their 20-year request, kind of evening out the fees here.
Yeah, so that's an interesting idea. So if there, and this is a question for council on how to construct it, that it could be sort of like a grant that says you come back in 2 years, and if you demonstrate all of these things, you get 20 or you get 18 or whatever it is that's allowed because it's the balance. And you don't actually even have to come back. Well, how do we do that? Maybe by
Compliance
Compliance?
hearing? No.
a compliance hearing. Yeah, a quick compliance hearing I'm not sure if that works. It could even be submit us all the stuff and it would be reviewed in an LSC review or something.
I thought a letter of substantial compliance.
Yeah,
I'd be happy. I would be okay with deferring to the executive director in a letter of substantial compliance showing that they've completed all that we've requested.
I think a compliance hearing would be better, no?
well, that's the thing. We can talk about the technical part, but I agree that this is an expense to have to hire the lawyer and bring them back and all that stuff. And we call them in, that's the difference. So there's no application. When we do the compliance hearing, we say, hi, come in a month and demonstrate that you've done it. So in terms of expense, it's probably the same expense as the LSC, but the board gets to discuss it. So that maybe that's a difference. But in terms of the technical aspect of it, it's a letter of substantial compliance to show that you complied. So it really is the ultimate letter of substantial compliance, right? Okay, so that's technical stuff. We don't need to bore the public who's listening with this stuff, but these are good ideas. Okay. And then, yeah.
Item number 27, 16949 BZ, 5270 Amboy Road, Staten Island.
Okay, hold this. Just a 2-year plus. Okay. Sorry, scrolling. Okay. After all that. So there were no submissions in the folder. This was adjourned in April and September. And the last time we heard this was a year ago. The applicant advised staff that he will appear to discuss this at the hearing. And as a reminder, we discussed the submission and drawings at review session on September 13th and had been satisfied with the submission. But just prior to the hearing date, the applicant requested adjournment stating that the gasoline station branding had changed and that the site might need to be reorganized. So yeah, it's confusing because it's a really different issue now. I'm not sure what's going on. Okay, so that's that for this one. You can go on because there's no comments. There's nothing for us to review.
Oh, okay. I didn't know if
Yeah.
anybody else was going to say anything. I just want to wait.
We
Okay,
don't
item
do
number.
anything, so there's nothing for us to discuss. So.
Okay. Item number 28, 82755 BZ, 245-20, 139th Avenue, Queens.
Okay. So we had asked that the oil tank be moved to allow for another parking spot. And the applicant replied that there is a 5-foot minimum setback from property lines and from the building requirement. So it can't be moved, as one might think, closer to the property line to get it out of the way. We didn't know that, so they cited to the code on that. However, they do propose to move the air pump, which was part of the issue, so as to encourage parking properly within the property lines. When it was on the corner, it encouraged instead parking on the sidewalk for the air pump. There is an area for the trash container, which is not proposed to be enclosed at all, but there are bollards to prevent its rolling. One commissioner, I think it was Commissioner Shabeta, had recommended be enclosed in board on board. I think that's kind of the technique that we saw in that residential site. I'm curious, it looks like there's room. Would that be possible to do? It looks like there is room to put an enclosure given on where they put it. Normally just using bollards, we request when there's absolutely no room for an enclosure. But here it looks like there's room, and that was a recommendation of Commissioner Shabeta. I believe we had asked for clarification and an update on the operational plan, specifically with respect to how often BP, who's the site, let's say, operational manager, how often BP will visit the site for monitoring, and what it will do if the site continues to operate out of compliance, and to reflect the number of parking spaces shown on the plan, which are now 5. But we didn't get that as far as I can tell. No updated operational plan. And the old operational plan says there are 2 parking spaces when now there are 5. So this is something we discussed at the last hearing. Those are my comments, Vice Chair.
Thank you. I was satisfied to see the changes proposed with regards to the relocation of the Air Vac. I just want to make sure we are all okay with the new proposed location of the dumpster, which is now going to be fronting along 139th Avenue. Initially, it was proposed against the wall by the building, and the dumpster would be visible from all the street frontages. I just want to make sure everybody's okay with that. So.
Good question, and more reason why it should be in an enclosure if it's there.
Well, yeah, my only recommendation, if at all it is to be there, maybe wrap the wall around along 139th, and then the trash enclosure can be behind that without having any fencing or anything like that.
Mm-hmm. Okay. All right. Worth looking. Thank you. Anything else?
No, thank you.
Charlotte Brown? You're muted if you don't, I can't see your face, so.
You're muted,
Okay.
Commissioner.
There. I had a pop-up that came up that I couldn't get to come down. I noticed the new location for the dumpster, and the site is very constrained by the shape and the fact that it's also fronting along the conduit and the belt. I really don't have a problem with the location of the dumpster that they found for it. And I'm satisfied with the rest of the application.
Thank you. Commissioner Sheta?
Thank you, Chair. Do you hear me?
Yeah.
Okay, yeah, regarding the location of the dumpster, I'm okay with that. And I have no further comments to add. Thank you.
Okay, Commissioner Shibata.
Thank you, Chair. I'm satisfied with this application. I have no further comments.
Okay, but how about it with respect to the dumpster being enclosed or anything like that?
I proposed the dumpster being enclosed. If it's, yeah, I do appreciate Commissioner Otley Brown's statement of the difficulty that this particular site has. If it's something that's feasible without making, because there's a lot of use in this odd lot. So if it's something that's practical, it was a suggestion. If it's not practical for the user, I can understand why.
Okay, thank you. Right.
And Madam Chair, may I follow up based on what I'm hearing? I would, I think this is something, if it's not feasible, okay, but it's something we should monitor and keep an eye out. Should, when the next term comes around, maybe some other resolution the board can take.
Okay, so at the very least, there should be something in the resolution that refers to this discussion.
Yeah.
Okay,
All right, thanks.
move on, Madam Chair.
Yeah, sorry. Okay, go ahead.
Go ahead. Item 29, 46758 BZ 17211 Northern Boulevard, Queens.
Scrolling. Okay. I thought this submission was very responsive, but I am a bit confused by the lumen spread and I guess and the noise studies diagrams. So the updated lumen spread diagram shows lighting levels at the property lines are higher in several places than they were in the last study. I'm getting the impression that the decimal points are missing because it used to say like 0.1, now it says 1. So always don't forget your decimal points if relevant, right? In fact, never forget your decimal points, just move them to the other side if they're in the wrong place. The updated noise study, I think, shows comparison to ambient for the vacuum and air pump on the residential property line with insignificant difference. I think that's what it's doing. There are two values on either side of ambient. So I believe what it's showing is there's no appreciable difference between when those things are on versus when they're off at the property lines. Notes were added to the landscaping plan to indicate that at present it is maintained by the residential neighbor, but if such maintenance stops, it will be planned as shown in the proposed plans. But view 1 of 2 and parts of view 2 in recently submitted photos actually show a very shabby site in need of new asphalt surfacing or skim coating, new trash enclosure fence that we said should be steel doors, and repainting on masonry walls needed. The applicant states this work requires permits, or some of the work requires permits, and the plans show the required improvements. So maybe the photographs didn't properly represent, or let's say the explanation for the photographs didn't properly represent why we're being shown the photographs. Is that just simply what it looks like today versus what it's going to look like tomorrow? Because that work should be done. And I understand if some of it requires permits, then it can't be done until there are permits, and so on. Okay. Vice Chair Sean.
Yeah, I found the lumen and the noise study kind of a little bit confusing. I had a question with regards to the noise reading. I was trying to look through the resolutions and other things. It wasn't clear to me why a noise study was provided, or did we require it? I was going through my notes. Maybe if it's not required or provided, I'm not even sure why it's being shown, and it should be eliminated from the plans. That would be my recommendation first. With regards to the lumen, the photo that the applicant provided, it showed that the abutting building along Utopia Parkway that has a side, I think it's like its driveway that abuts the rear lot line, has these two lights that are lighting the side yard. So I'm wondering, during their lumen count, were those lights there, and that affected some of the increased light levels, especially along the northern rear lot line, because that's the only place where there is an increase in the rear lot line lumen count. Yes, Commissioner Shetta, if you look at the building that's extending out by the window, and above that, there are these two light fixtures on the building. So that is to light the side, the driveway. And I'm wondering if those may have affected the lumen count, because the lumen count there is not zero. Otherwise, again, I wasn't clear which of some of these tasks required DOB approval, but the applicant can maybe clarify that during the hearing. Otherwise, I was satisfied.
Thank you. Just to go back with noise analysis. Yeah, so I'm not sure exactly why they decided to do it. I think that they overheard conversations on drive-throughs and imported that into analysis for this use. And I think it was either the last time we had the hearing, or I don't remember how many hearings there are without doing a lot of scrolling. I also said just take out that noise information, because they weren't comparing to ambient at that time. They were just taking readings, which sounded terrible. And meanwhile, you're on this highway and there's trucks passing and everything. So I said, just take it out. And instead they did an ambient analysis also, which is interesting. But I agree that mostly we don't ask for this unless in the case of that McDonald's, we had huge noise complaints, so that's a different, right? So I agree with you on that. Okay, thank you. Okay, so Commissioner Shipman. I'm sorry.
What about me?
Brown. Sorry. Commissioner Ollie Brown.
So the landscaping that they placed in that lot line along Utopia actually looks really nice, and the fencing looks good back there. But the compliance photos to me point out, like you said, the need for there to be some pavement work because the pavement is in poor condition, and also points out to me that the garbage enclosure as it currently exists definitely needs to be replaced with the proper concrete walls and the steel doors because it's just not in good condition anymore.
Thank you. Okay, thank you. Yeah, you know, it's always funny to me. They take a picture, it looks horrible, and then they submit it and say, yay, I guess. Or they don't say yay, they don't say anything. They don't say, we're sorry, it's not going to look like this in the future. You know, a little cover letter would be very helpful. Thank you. Okay, Commissioner Shetta.
Thank you, Chair. Yeah, everything on this application looks fine, except for two things. The first one is the number of hearings. We're at 4, 2 of them got postponed. I wish this could have been like 2, like the other application. The reason I'm talking about this frequently because I did hear that we've been complained of because of multiple hearings on cases that do not need to be like 4 hearings or 5 hearings. That's why I'm focusing on this. I want to clear our side that it's not our fault. I'm talking about, when I say our, I'm talking about the board here. And then on this application, at the very last hearing, I spoke about 2 things. Number 1, I said, why do we need noise? And why you're putting the noise on the same plan as the luminous spread? If you want to submit him, if you're volunteering to submit noise and we didn't ask for him, please do them in a separate plan. This is not being done. Still, the noise is volunteered, it's not taken away, and it is still on the same plan as the luminous spread. And on the luminous spread, previously, I did ask whether the measurements or whatever the numbers provided to the board during the last hearing were coming from measurements, and if they were coming from measurements, why don't we have lights on, lights off, so we don't guess? Like the vice chair just looked at that lights on by the side of the house, by the side yard, and she's trying to find the reason why the reading has gone from the previous submission from almost like 4 or something like that to 32 in this submission.
Yeah.
I would love if the applicants just listen to us. And when we say something, I swear it's not to give you guys a hard time. It's to help you resolve issues in a timely manner. So your applicant or your whoever pay the owner doesn't pay for 6 hearings or 8 hearings. It's just 1, maximum 2, and we're done. Lights, I'm still confused whether this is on or off or both. We have 32 and 28 right by the light pool, which makes me like skeptical. Is this coming from the light pool? I did look at, if you look at the picture, and I wanna share my screen one more time. This is the picture for the light pool that is submitted. This time we're talking about shielding. In their submission, they talked about shielding. Where is the shielding here? We need applicants to listen to us, please. I wish I could have voted on this application, this hearing, but yet it's one more hearing, and who knows? Thank you.
Thank you. I also, to add to that, thank you. You know, if an applicant doesn't understand something that the board said and doesn't process it quickly enough to ask questions during the hearing, that's why you're supposed to reach out to the project manager and ask for clarification. And the project manager will get those issues clarified and get back to the applicant. So applicants should not be kind of wandering around in the dark if they are not understanding a direction. So thank you for that.
Or even ask us on the fly. If I say, look, maybe I'm not clear sometimes because I get emotional, and I get emotional about applicants, not about us. If I'm not clear, ask me once and twice. Stop me if this is for like the benefit of the case. If one of the applicants stopped me while like talking and to ask me about something, I wouldn't be aggravated. I would welcome that.
Yeah, okay. Thank you. All right, and Commissioner Shabeta.
Thank you, Chair. So I have some of the similar comments with regard to the trash enclosure and the asphalt. I did appreciate the removal of the floodlights. I do just want one comment I don't think was just a clarification. With regard to the landscaping that's maintained by the owner, I just want to change
By the
the
neighbor.
note. By the
By the
neighbor.
neighbor, yeah.
I just want to change the note slightly to read that it is the applicant's applicant is to ensure that landscaping is maintained. So, as opposed to in the case that the owner doesn't do it, just a little more clarity and brevity, so they know it's still their responsibility to ensure that that is sightly. Other than that, I have no other comments.
That's a good idea. Thank you. Okay.
Good.
Mhm.
Move on.
Yeah.
Okay, item number 30, 52358 BC, 11730 Farmers Boulevard, Queens.
Okay. While the applicant's representative was very responsive to comments, the photos show a sort of half-hearted in-field response, which does not really do justice to the neighborhood. There's an acoustical blanket that was properly installed in some places and then just sort of draped over stuff in others. There's chain link fencing that's complete and slatted in some places, but not in others. And it's missing its top rail, or has a flying top rail in places. Those may be remnants of barbed wire. When you remove the barbed wire, you also have to remove the rail that supported it. So it's quite messy with respect to the fence. The trash enclosure is chain link with slats, but very open as compared to the preferred masonry enclosure and steel doors. But even with the slats, it's not concealing the trash much. The new arbor vitae that was planted, but no landscaping is shown in the dirt area adjacent to it on the western property line, which was supposed to be planted, I think they said, with a vegetable garden. I think the people who work there actually take advantage of that area for vegetables. So, but there's nothing right now. The photographs show dirt. On the proposed drawings, no landscaping is proposed along the western property line adjacent to the residential property, and also adjacent to the clothes bins, and it really needs to be. It's also shown in photo 23. So just the landscaping stops abruptly, and the explanation is we don't want to have to cut the asphalt, but that's actually what is done often to improve the buffering situation with respect to the residential neighbors. So that can't be the response. We have had some success with above ground planting beds that are high, like I think they're 4 feet high and almost 4 feet front to back depth. So that's a way of avoiding having to dig. And we have, I think we still have a detail on that. That was Mr. Rampula's case, I believe. On the other hand, the vacuum and air pumps were removed as discussed. And so those are my comments. Vice Chair Shonda?
It took a while for us to get here. So I'm glad to see the improvements made, but I agree it can be done better, especially with the slats and the and the acoustical fencing. I think if we were to proceed with it, we do a close and wait for the applicant to do a little bit more cleanup, sprucing, and then we vote it out.
All right, thank you. Commissioner Ollie Brown.
I agree with you both that they aren't there yet. It seems like they are trying to comply, but just not going 100% because they're paying attention to the detail, but not the overall effect of it. So to slap that acoustical fence up there, like in the haphazard way they did, I'm sure they were guided by wanting to
Commissioner
reduce.
Commissioner Otley Brown, you're breaking up.
Oh, can you hear me now? Can you hear me?
Yes.
So I sure they were trying to respond to comments about limiting noise, but they need to think about what that actually must look like to the neighbor, because the slatted fence is not completely slatted all the way to the top. So it looks like there's some kind of nylon padding that's sticking out over the fence. The effect for the neighbor is just one that isn't very nice looking. So maybe it'll be silent, but now they have an eyesore of a fence with something slapped halfway over it that's showing itself at the top, which is what I mean by they're paying attention to the detail, but not looking at the overall effect of what they're doing. And so then I look at their garbage enclosure that is the same old fence enclosure, and okay, the fence enclosure is in place, but they have a rat box, a rodent box that's sitting outside of the fence enclosure in one of the photos, which shows me that they have a rodent problem. So if they have a rodent problem, it's not enough just to have a fenced-in enclosure that you could shut the doors, because you still have a problem. So perhaps they should consider the concrete enclosure with the steel doors so they don't have the rat box just sitting there. So that's what I'm saying. That's why I don't feel like they're all the way there yet.
Okay, thank you. And before we go on with the next person, there is something going on with your speaker or your mic that really is scratchy. I don't know what there is to do about it, but maybe play around with some stuff and we can run a test before we speak the next time, okay? And I do want to point out that the concrete enclosures with steel doors do have some effect on reducing the vermin, but they're not 100%. Because none of these dumpsters are designed for the animals to not get inside, right? There's always, when you see the dumpsters, there's always like a little space, and because the rats especially, well, mice also, but less of a scary issue, can squish down so flat, they can get inside. And especially if you don't have a top on the dumpster, they definitely get inside. So that's why I'm so interested in that new product that's being made at the Brooklyn Navy Yard. They are impervious, apparently, like the rodents cannot figure out how to get in, and they don't eat the stuff. So anyway, that's this ongoing thing, which I hope Department of Sanitation is working on these days. But so thank you for that. Okay, Commissioner Sheta.
Thank you, Chair. I agree that they are making progress, but I believe it didn't need to be 7 hearings. 2 of them were adjourned. Yeah, I'm willing to continue listening. I agree with the comments being raised so far, and let's see what they're gonna put before us during their testimony.
Okay, thank you, Commissioner Shibata.
Thank you, Chair. So I certainly had some of the same comments. This is one of those, I don't want to micromanage how to do it right. It just seems that this was, they listened to our comments, but applied them in the most bare minimum standard. Even the sliding on the trash enclosure, at the very least, it could have been uniform. So there really wasn't any attention to how this impacts the neighbors. Now, I don't know if the solution is for the trash enclosure is a concrete enclosure. I'm not sure but they haven't provided us with anything that seems like a feasible solution yet. I do agree that we can give them the time, we can close and give them the time to address our comments, and hopefully they come with a more substantial submission with regard to what is actually the case on the site as is, as opposed to just words on paper.
Okay, thank you. You know, it's one of the things that I've learned over the course of all this time is when you don't create standards, then the solution, the responses are haphazard. So that's why when we created, for example, the concrete wall trash enclosure with the steel doors, which has a fixed detail, everyone knows what to build. And the same with the planter. Now we have details for the planters. Everyone knows what to build. If you're not specific like that, you're going to get, you know, and I don't blame them. It costs money to do these things. They don't hire people who are skilled at a particular thing. It's just like a bunch of guys who come and they install some fences, like what they did in the backyard of their houses or whatever. So and without any specific outcome, which is why, like in architectural projects, you have specifications and drawings that are so particular and specific that there can't be any variation from the goal. So the loosey-goosey approach is, in the end, makes it actually more expensive for the applicant because it's a do-over, as opposed to do it like this, hire people who know how to do it like this, and just get it done. Yeah, Commissioner, go ahead.
So I hope that they would make cost-benefit analyses and provide us with something. We've already said that the concrete enclosure as a suggestion is something that would be acceptable. If they're willing to do, if they make a cost-benefit analysis, I would hope that they would either do that or something equally as good, because they don't want to come back when we're disappointed, when we say that isn't sufficient, like we are doing right now. So hopefully they, while I would be satisfied with a concrete enclosure, if during the hearing they come up with something that works as well, you know, we could talk about it. But I have nothing further after that.
Thank you. Okay.
Madam Chair, I just want to add the photo that has been submitted. This is, I think, photo number 31, which shows that the bollards are in place to keep the vehicles from encroaching onto the side yard. If you notice that the car that is parked there, it does not have a license plate. So again, I think this goes to the point. We have been very clear, and the prior board also has been very clear that there should be no sales of any vehicles. So I think the applicant needs to hear these very clearly and have its client follow those directions clearly.
All right. Also, yeah. So, you know, this is again one of those things. If you're going to submit photographs, make sure your photos don't show anything that's indicating an illegal use. You know, that's the kind of thing. We get the photographs and they reveal all these defects. At the very least, be more editorial on the photographs you submit. Okay, I'm indicating no sale of vehicles for future conditions, right? Among many others. Okay.
Move on, Madam Chair.
Yes.
Appeals calendar, continued hearings. Item number 31, 2020-67A, 1 Ballard Avenue, Staten Island.
We had received previously conditional sign off from DOT as a part of a letter stating that the capital improvement project the community board referred to had been canceled, but advising that DEP may have concerns with the project, so that applicant should reach out to DEP So I'm not sure what happened with that. I'd like to know whether the applicant modified the street tree location as requested by DOT or shown the pedestrian ramp upgrades. I didn't see that on the builder's pavement plan. It just says existing ramp, and I don't know what street tree location DOT was referring to. There is now a DEP approved site plan for site connection approval dated June 8th, 2022. I'm not clear about whether that addresses the concerns expressed by city DCP in their letter about a DEP, or maybe that was, yeah, about a DEP capital project. Or was that, did I have that wrong? It's a DOT letter about a DEP capital project. So it's a different question, site connection versus whether they have plans to run sewers through the site, right? So I just don't know, and I think we should get clarification from DEP. Okay. A draft builder's pavement plan was also submitted, which will be reviewed by DOB and DOT after our decision. The project must still go through city planning for subdivision approval for the South Richmond Special District. And I don't think I saw any notations on the plans about possible required 7201G bulk waivers. We were supposed to have gotten that specifically. Those are my comments, Vice Chair.
So on the last set of builder's pavement plan that was submitted dated 6/27, the applicant is proposing to remove the existing tree from the nearest curb cut and locate it 7 feet from the proposed curb cut.
Okay.
That was a comment that was raised at the last hearing. I do not see a sign off from fire department. And also I'm satisfied with the application. I would recommend that if we were to close this, we condition it with the DOT comment, which is upgrade the pedestrian ramp adjacent to the property to comply with ADA per compliance with DOT requirement.
ADA ramp, it's really the sidewalk curb ramp, right?
Yeah, I'm just stating what's in the letter. So that's how it was stated, but yes, you're right.
Yeah, okay. Okay, thank you. Commissioner Otley Brown.
Can you hear me?
Yes.
I switched internet. I have no additional comments.
Okay, thank you. Commissioner Shetton.
Thank you, Chair. Yeah, I didn't see feedback from FDNY. And in addition to the condition with respect to the DOT, the applicant is saying that the application before DCP for the subdivision is still pending, and he's okay with the condition on finalizing this application after the grant. I would be fine with a condition like that. Thank you.
Okay, thank you. And Commissioner Shetton.
Despite needing to hear from FDNY, I am satisfied with this application. So pending FDNY's input.
Okay, pending. Okay. Thanks, Tony.
Yeah, the reason why I raised my hand is because I had identified they had the subdivision certification. So I had reached out to DEP, and I had stated, I know there was a prior discussion that it was on hold for BSA, but I believe we typically require they go through CPC process before BSA is completed. But so Daniel Vieira from CPC, his predecessor was, Chris Hadawin and Alina Farishta, who have now left DCP. It is my understanding as well, since the land use application at DCP is only seeking a subdivision certification that would create an undevelopable non-complying zoning lot, 1 Ballard Avenue, absent a BSA approval for the GCL 35. In this instance, would BSA have concerns with proceeding with the application? So my hearing is that the board is okay with doing the GCL first, correct?
And
Okay.
in terms of chicken and egg, I agree in this case with city planning, because how can they entertain construction in the bed of a map street? Like, it's not allowed. So first they need to know it's being allowed, and then they can entertain it. So we're definitely, whichever thing comes first, the chicken or the egg, or the thing.
Okay, so, so then I'm clear as to send back to DCP that we will vote on the GCL prior, and then they can do, or,
Yes.
okay, so they're okay, okay. We're gonna do first and then they'll go second, okay. Okey doke, great.
Oh, what do we got? Okay,
Okay, do we have everybody? I can go on?
yes.
Okay. Item number 32, 2021-2A through 2021-7A, 9121 Hollis Avenue, also known as 19101, 09, 13, 90, 19201, 19205, 19213 Hollis Avenue, Queens. This is a GCL 35.
Okay. So again, as you said, this is a GCL 35 application where the widening line extends approximately 20 feet past the private property line. So in that case, and there are houses situated within that 20-foot widening line or proposed. So I'd like to know, is 72 or 72-01G bulk waivers required? Applicant has to request them specifically, so we know. I'm just guessing it's yards and height and setback. But it may be other things. The applicant has to be specific in the request so that the resolution is clear. We do have a letter of no objection from DEP, but I don't see anything from DOT, importantly, DOT or fire department. Maybe if anybody sees it, please let me know. I didn't find it. Vice Chair.
Sorry, thank you. Yes, I also don't see DOT and FDNY comments. I had raised the comment last time with regards to realigning the sidewalk, especially at the intersection of Hollis Avenue and 100th Avenue. As I would say, an effort has been made to realign the sidewalk, though I was expecting more area for greening, along the curb side, and also a continuation of a green strip along the lot line. Which in the case of lot 46 does not wrap around the lot line. If you look at the other lots, there is a small strip of green abutting the property in the case of lot 46, which is the furthest most lot closest to the intersection of Hollis and 100th. The strip just kind of stops. I think lot 46 has enough of front yard and open space requirement that it meets, that some amount of strip can be provided that wraps along as a continuation of this development, and it also beautifies the site and makes it uniform. So
Can I suggest with that, you showed us during the last hearing your sketch, which is now in the record, right? I don't know if that sketch was shared with the applicant or if there's anything different that you want to do with that.
It is, sorry.
No, or perhaps there's something a little different you want to do with that sketch, or in fact, sketch over what they proposed. Because it's possible, I took a picture, a screenshot of it, and I immediately put it on my notes, right? If they didn't do that, they may have been making their suggestion from memory. We could have now that it's in the record, your sketch is in the record, we could have the project manager just share that directly with the applicant. And let's give it another try.
Sure. Yeah, it definitely is not what I was envisioning. So I'm not sure if it was shared. Maybe the applicant can discuss it. Yes, I was looking for a shifting of lot line of lot 46, a little bit inward. That would have allowed for a little bit more of a squared out green space along the curbside, and a very small strip that runs along. It's probably even not even a foot that runs along the property line that actually is shown in every one of the property, and that's an easy one to be fixed. So yeah, maybe the applicant can tell us, maybe they got the plan or maybe they didn't get the plan. And either way, I would like to hear the applicant's thought that went into doing this.
Yeah.
Okay, just FYI, the fire department has no objection on this application.
Great.
Sorry to interrupt the flow of conversations.
Right. I saw it, but I wasn't sure it was this case. So, okay.
I'm just
I
saying.
thought it was Ballard.
Yeah.
No, I'm sending it to you now. That was valid, Madam Commissioner.
So this is a different one. So Ballard. Yeah, that's right. Okay.
I'm sending it to you now.
Okay, good. Okay, so going to Commissioner Ollie Brown. Thank you.
I have no comments.
Shetta
Thank you, Chair. I have nothing further to add.
and Commissioner Shabbat.
Thank you, Chair. I have nothing further to add.
Right.
We good?
Yeah.
Okay. The next one is new cases, item number 33, 2021-57A, 1900 Holland Boulevard, Staten Island. And I did forward a DOT letter. Did everyone see it? It was last week.
Don't know.
Comment letter from DOT.
Okay, so Vice Chair Shanda, you're going to take this one. Did you receive that?
Yes, I did.
Okay.
Thank you.
Okay.
Should I
Yeah.
take off? Okay.
Yeah.
We have received proof of service for initial filing and public hearing. Community board disapproved this application, and upon further clarification, community board stated that this community board specifically has a long standing of opposing to all developments within the bed of unmapped street. The applicant is seeking a GCL 35 waiver to develop a 2-story commercial building located partially within the bed of a mapped but unbuilt portion of Jefferson Avenue. This is a corner lot that is vacant with a 30-foot frontage of Highland Boulevard and a 63-foot frontage on Jefferson Avenue. I believe there was a building that was located on the side, a 1-story building, commercial building that was damaged by Hurricane Sandy and was ordered to be demolished because of its poor condition. It is located in a flood zone, and the elevation is, it's zone AE with an elevation of 12 foot. The applicant is proposing a 2-story building, use group 6 commercial, with a parking, with a 1-car parking space on the ground floor, I would call it. I just want to start off by saying that the applicant needs to correct the terminology. Per zoning resolution 64322C with regards to flood proofing ground floors. First of all, what is listed, shown in the plan as a first floor is a cellar, because more than 50% of it is below the flood elevation level. So it shouldn't be called first floor, it should be called cellar. And then the second floor should be called the first floor, just to be consistent so that we know which one is counted towards floor area and which one is not. With regards to DOT had extensive comments on this project. Specifically, I think the comments were around, I just want to look at the DOT comments. I wrote it down somewhere. just give me a second. The DOT issued a comment letter on 7/14, and it had extensive comments with regards to the nature of the two frontages, but specifically it identified, one of the comments was regards to the parking space that is located on site, and asked the applicant to dimension the curb cuts and which curb cut is actually going to access the sidewalk. And that was also my comment. The site plan is not at all clear as to where the curb cuts are and what the widths of the curb cuts are. What the site plan does show that the ground floor or the cellar has these roll down windows on Jefferson, and it has clear glass along Highland Boulevard. And there is one vehicle that is parked within the garage. So I would like the applicant to clarify as to what exactly is going to happen in that cellar space. As I look at, read the zoning resolution section ZR 64322C, which is if you have a flood-proof ground floor, it states, for buildings along primary street frontages or portions thereof as defined in section 64-11, floor space located below the first story above the flood elevation and within 30 feet of the street wall along such primary street frontages may be extended for calculation of floor area, provided that there are many 1, 2, 3s, but I'll jump to the 3, is that such floor area be limited to non-residential uses other than accessory parking or public parking garages and subject to minimum depth requirements set forth in section 37-32. 4, ground floor and ground floor level street walls shall be glazed in accordance with the provisions set forth in section 37-34. So when I read through this, I'm not sure it's meeting all the requirements stated in ZR section 64322. So we could do, it is before us for a GCL 35. What we could do is we could leave it to DOB to ensure that the building would comply with all the underlying regulations with regards to use and bulk, and that it meets all the conditions stipulated by all our reviewing sister agencies. We haven't received all of them. We just have received some comments. We do not have sign off from everybody. Also, the applicant should show in the drawing the method of flood proofing that is being proposed. It's not clear. And the proposed use and the plan, I think what is being said and what is shown doesn't seem to match. So that's why I have a lot of those questions. The statement of fact also needs to be clarified with regards to the usage of the terminology. First floor, second floor, it should be cellar and first floor. Those are my initial comments.
Thank you. Just in terms of the back in the day, kind of when it really matters, where we're concerned about designing the building like the 73-622s, and it's clearly in a floodplain and clearly maybe not complying with flood regs, then we ask them to go to DOB to get a sign off on that. But in this case, because really it's just, as I said about the school building, it's just to allow construction of a building in the bed of a map street. That's something where we can alert DOB in the resolution that, flood regulation compliance is for DOB to review, just alerting them because they don't think we looked at it. Yeah.
Mm-hmm. Yes, I agree with you. Yeah.
Okay. Good. Thank you. So Commissioner Ollie.
Yeah, I'm trying to find where.
You're frozen.
Excuse me, I initially said curb cuts. Am I right that there are 2 curb cuts on Jefferson?
No, there's one.
Yeah, there are two, and but you're right. Actually, how did I miss this? You're right. There are two curb cuts on Jefferson, but if you align that with the way the parking space is, it doesn't make sense.
Exactly. That was my question. That's the one question I have about this is why are the curb cuts on Jefferson and the parking space appears to be parallel instead of perpendicular to make use of them?
Yeah, and I think that's probably why DOT raised that question.
No other
Thank you.
comments.
Thank you.
Okay, thank you. Commissioner Sheta.
Thank you, Chair. First of all, I want to say that they need to correct the site plan. The site plan describes the building as one-story building. I'm talking about like the first drawing.
Mhm.
Let me just give the number of that drawing. This is Z-001.00. If you look at the site plan, it says one-story building. My understanding is that the building will be 2 stories. In addition to this, when reading the statement of facts, it says that the building will be elevated above the flood, and like the first floor will be at elevation, I believe 14, if I recall, because the flood elevation in the FEMA map is 12. If you add the freeboard of 1 foot, that's 13, and then you elevate 1 foot on top of that. So this is elevation 14. That makes sense for me. But when looking at the plans and the sections show that the lowest floor is at elevation 4.41. I'm not sure if this is a local zero. Is this like the site datum? So it's a bit confusing, and I'm asking them to clarify that. Other than these 2 comments, I have nothing further.
So they're saying base flood BFE is 12.
Right.
So,
It's not big.
what?
Yes, base flood is 12. Yeah.
So, and then they're saying the first floor, which is the base plane, it's not really first floor, is 4.41. So that should be in NAVD 88, but it's true, it's not indicating that anywhere. So that should be clarified. But in terms of whether it's a 2-story building, that's, open for the various kinds of interpretation. As the vice chair said, under the flood regs, anything below the base flood is considered a cellar. So the first floor is really what's being labeled here is the second floor. So a more accurate representation might be a 1-story building above an above grade cellar. Something like that. That might clarify what's really going on. Anyway. Okay. Anything else?
No, thank you.
Okay. And Commissioner Shabbat.
Thank you, Chair. I have a question for Tony. Tony, did we receive any response? So in September of 21, DEP sent comments, and then in April of 22, they were responding to. Did DEP make any response to those comments?
I don't see that. I can check again, but I don't see that.
Okay.
We have a DEP sign off.
Okay.
I'm sorry, DEP sign off, yes.
I didn't
Yeah,
see
I'm
that.
sorry.
Yeah.
All right. Other than
I
that,
didn't mention, we have a DEP.
okay, so we have a DEP.
Can't read my own real notes.
This case was a Hurricane Sandy was knocked down. The building that was on this property was knocked down. So they're coming to build a building on a map street that had a building on it already, but only got knocked down because of the hurricane. So
Right.
I do want to do everything I can to expedite this because it does seem a bit bureaucratic at this point with this particular. But I do want to hear back from the sister agencies. I also, just for my own edification, do they have a tenant already for this location? Because we don't know what's going to be there. I just want to know if they have something lined up.
Not that I'm aware of.
Okay, and nothing further from me then.
Sorry. Where's the DEP?
We have DOT sign off, not DOT sign off, DOT comments.
DEP sign off, I don't find. I have DOT comments.
It's dated, DP issued a sign-off letter on 6/13/2022.
6/30, maybe it's just buried. Oh, I see. It's just
Yeah,
in the-
thank you for the date, Madam Vice
Yeah,
Chair.
it's not in the interagency folder.
No, it's not.
Yeah,
no.
it's floating. Okay,
Oh, it's floating. I'm sorry. I'll fix that.
has no objections. Okay, that's fine.
Yeah.
Okay. All right, good. I guess that's it then, right? Everybody spoke? Yes.
Yeah. Okay. So the next item is item number 34, 2022-2A, 728 Court Street, Brooklyn. And as we stated before, this case will be postponed.
Yes, okay.
So then that concludes the review session for July 18th.
Okay, so let's take, well, we can round this. Let's take what ultimately is almost a 40-minute break so that we can start again at 1. Start with the public hearing at 1 p.m. Okay? Thank you, everyone.
Where's my
Okay, could everyone come back, please? Great.
Are we ready?
Oh, we have a quorum enough to start. Vice Chair has to join, but we have a quorum, so we can just get started with, oh, there she is. Okay.
Okay. Good afternoon. This is the Board of Standards and Appeals public hearing for July 18, 2022. The first item up is SOC calendar, continued hearing items, item number 26, 1069, 27 BZ, 6702, 6724 New York Avenue, Brooklyn.
Okay. If this is your case, please raise your Zoom hand. I don't see Mr. Catrona's name in the list. Does anybody know if his case is being represented by someone different? Or can someone text him, let him know?
Wednesday, I'm gonna take out. Friday afternoon.
It's okay.
Okay. Yeah.
Text.
Apologies, there's going to be some banging in my adjacent.
Yeah, I apologize also. I have to keep the office door open over here. It is so warm in here today.
I'm sure.
On both sides of the office, so I don't know how people are doing it. Glenn. You're on.
Should we move on to the next one and then do it a second call? Unless you're able to reach him.
I just spoke to Emery. She's telling Glenn to join.
Okay. So I have someone practicing the saxophone next door and someone banging hammers and nails next door. So
Oh,
sorry if there's interference, but that's life.
Welcome to, I was going to say New York, but it's the island. It's still the same.
Yeah. Not just New York, it's living unless I guess you live in the mountains, but I don't even know if that would work. And there's like those noisy animals, etc.
It's not joining.
Okay. Anybody want to sing a tune?
No singing to BSA.
You can listen to the saxophone. He's gotten a lot better over the last 2 years. This is a COVID saxophone learning. At the beginning, it was really difficult. Every morning at 11, practicing badly the scales, squeaking for an hour. Yikes.
Hi.
Mr. Catrona, how are you?
Unmute. Thank you. Are you the only one, Mr. Catrona?
Yes, I am.
Raise your right hand. Do you affirm, tell the truth, the whole truth, and nothing but the truth in your testimony before this board to respond honestly to board member questions?
Yes, I do.
State your name for the record and proceed.
Glenn Catrona, representing the car wash on New Utrecht Avenue. I'm sorry, need to get my address here. Good afternoon, Madam Chair and Commissioners and BSA staff. We're talking about the car wash at this point, right? I have two
Yes.
today. Okay, great. So I listened in on the executive session. And just a couple of comments here that I'd like to make regarding this here. So this letter that I put out on the 15th was because apparently there was some sort of confusion where some documents populated the BSA submit that confused the issue. That was clarified, but there were a couple of items that were left open that I wanted to comment on. So Tony and Carla had advised me to put together a simple letter, just a statement of improvements in the proposed timeline. So yes, indeed, the owner operator is securing bids to close this here curb cut. And I have no idea what happened in 2002 and why that wasn't executed along the time. There was also some discussion about, you know, how to structure this here moving forward. The fact is that what we'd like to do is to make these improvements, come back to the board and just close this here out fully and not have to come back. The prices that are coming back for the curb cut, as well as removing that portion of asphalt that actually is over the property line and on city property, two of the bids came back exorbitant. They're dealing with the overhead L, and they are required to utilize a standard steel face curbs, et cetera, and just the numbers are coming in crazy. So we have the operator has two other contractors that are in the process of providing prices. What we'd like to do is to secure a contractor, remove and replace the drop curb with a standard curb, that curb cut along Utrecht Avenue, closest to Ovington Avenue, and also to remove the macadam, the asphalt, from the portion of the sidewalk beyond the property lines. There was a discussion, yes, the prior extension of term was approved with that, but yes, indeed, it's over the property line, and I believe that that's the posture of the board, that we want to be compliant. So DOT would not approve that situation, I would imagine. So we're moving straight forward to take care of that. The issue with the survey, Commissioner Chet, I just want to, let you know that in the industry today, the minimum of approximately 6 weeks before a surveyor can even get out on site. The reason why I mention that is because Vice Chair had asked for a survey because she felt there was a pinch point on the portion of the building at the corner of 15th Avenue, the peninsula point there, where she thought that the dimensions looked different from prior filings. I spoke with the owner, who is away for the winter months, told me, yes, I have a survey in my records. And when he returned, which was prior to my submission, and my effort was to get the submission in on timely, we submitted a survey. The survey is absolutely inaccurate, as we had verified it. It's not sealed. And my concern with that there was a question about, the lengths of the curb cuts. Well, we've done this here before. Nothing is being changed with it. I believe that I have a note on the drawing that it's the Department of Buildings' responsibility for the, for the legality of curbs, and that takes us here off of the BSA. But I believe that one or two things. I would like to potentially have the opportunity to have my staff field measure. We're not doing any construction, just to get an accurate length of the curb cuts and to measure the distances between the curb cuts, because I would say that, based on my understanding right now, our plans are accurate with what is reflected in the field in terms of the distances. And then that took me to a refined maneuverability plan, which I agree, we show no turning radiuses on that maneuverability plan. We can update that maneuverability plan, but I didn't want to do it haphazardly without having a greater understanding of the curb cut lengths and the distance between the curb cuts, because then the maneuverability plan would be affected if there was some inaccuracy that was there. that was purely the case. I heard about the vacuum cleaner that's on wheels. To locate that, we will prepare a new submission and to speak about that there. You know, I think those were the significant items, but the point is that it's, you know, one of the things as applicants, and, you know, we refer to responses from us as applicants, which are really truly reflected often by the actions of our clients. And this client, I will tell you, is absolutely moving forward. It's just, I don't really want to discuss numbers here. I don't think it's germane to this conversation, but it's exorbitant, and they need to find a way to find a contractor that will, you know, be responsible to complete and fix this work, but also at a price that's reasonable and affordable. In my mind, I would like to have the opportunity to give me some reasonable time. My outside request for these several items that were on this letter from the 15th is 3 months. I think it would be reasonable for us to have this work completed and for me to come back in with a submission that reflects the upgrades, and you know, that we just simply put closure to this here case and move on to the next. That would be my suggestion. I believe we can do it in the 3-month time frame, and we would prefer to do it that way if it's okay with this board.
That makes sense to me. I'd suggest that, I think that's what you're suggesting. We close, but maybe give you a little more buffer, 4 months. So where we were in July, so 4 months puts you, you know, if you get 4 months, then it's towards the end of the freeze, towards the beginning of the freeze period. So at least that you have that chance to even install in November, you know. So maybe we say put you on for a submission maybe in December. Does that make sense? That way you could have installed in November if it gets pushed out to that. Does that make sense?
Yeah.
Okay. So,
you know, I mean, even though you would give me a submission date relative to that hearing, or if that's the submission date, I mean, if the work gets done sooner than later, you know, we can always submit and be prepared for the hearing date.
yes, that's fine. As long as you're okay with it being outside that, but I don't really like, you know, if it's possible to avoid an adjournment date, and 3 months sounds a little tight to me, given that you still haven't contracted.
Fair
Right.
enough. 4 months would be great, and the idea is to come back to the board with a submission that speaks to these improvements, and again, to move it and be done.
Okay, great. Okay. Any comments from Commissioner Shetta? Go ahead.
Commissioner Shetta.
Shetta, you're muted. You're muted.
I apologize. I thought I did unmute. Yeah, but thank you for the clarification regarding the time frame of retaining a surveyor. I totally understand that. But is the plan to measure the curb cut, like your office will do that?
Commissioner, you know, I would prefer that. We're not doing any construction. I mean, look, from a coordinate standpoint, we're not land surveyors, but I believe that we can get a very accurate read on the curb cut lengths and the dimensions between the curb cuts. And
I have a suggestion.
I would prefer to go that route again, because I think we'll get the same results. We'll bolster up the maneuverability plan, and we'd get what we need from that and feel confident that our plans are correct. And you know, to potentially save some money for the landowner, for the operator of the facility, again, because the improvements are significant right now. They went and they actually looked at that asphalt. Can't really tell if it's a matter of removing that asphalt and that the sidewalk below that is in some reasonable shape and could be cleaned up enough. I think it's a replacement. So the numbers are significant. So I would like to, you know, say that we would field measure and, you know, based on our results, reflect that in the plans. And yes.
If the rest of the board is okay with it, I'm fine with it. But I'll like make this on a tiny condition to make sure that it's accurate. If somebody from your office will do that, I'm sharing my screen. I'm asking them, if you're measuring, let's say this curb cut, I would suggest that you see this point here, the corner,
Yes.
and take probably 50 or even 100 foot on that direction and take another mark on the building. Use the building as a baseline and then give us a measurement from this corner to that end, and from that second point to that end, and same thing for the other guy, and then give us the lens. This way we're gonna have like a double check on the measurements and the accuracy of that. Thank you.
Right, and before you take that away, I'd like to suggest also, and I see the vice chair has her hand up, the pinch point question. That one, I'm curious about the distance from the actual curb to the building. So if you can make measurements from the curb point rather than from the property line, since we don't really know where it is, from the curb edge to the building, perpendicular to the building, or perpendicular to the curb, I guess, perpendicular to the curb. No, we don't like that.
It's not needed. If they measure, if let's say this is one base point, the second base point is 100 feet away, like on a tiny piece of paper, you can draw a line with 2 points 100 feet away. And then if they measure 2 measurements to here, you can draw a circle and then a second circle from the second point, they intersect at a point, and then you repeat the same thing for the other corner. So you get the direction and the exact location of the curb cut with respect to the building. And in addition to that, as bonus, you get the width of the curb cut. So the way I just described in measuring this is like gives you everything. In addition to that, it's probably appropriate to like direct measure the width of the curb cut to make sure that things are consistent. So it's gonna be already there.
So my question, and just 1 second, Vice Chair, my question is, what is the distance between the corner of the building
This guy
and curb in front of it? Will this give you that?
you're talking about this distance, right?
Yeah.
Yes.
It'll give you that. Okay.
Yep, definitely.
That's what we want, right?
That's actually what I was willing to get as a bonus. And in addition to that, to get something to doubly check the measurements.
Okay, good. Okay, thank you, Vice Chair.
Thank you. This is a question for you and probably for General Counsel. If there is, from the survey, we know there is a change in the curb cut width. And the prior drawings, we don't know what the dimensions are. Would it make sense to also indicate that this is a legalization of an existing condition, that the curb cut widths have widened?
So we don't regulate the curb cuts, right? And as far as I know, we didn't on this case grant them any kind of a waiver on curb cut width, right? So I kind of prefer not to mention it. Otherwise, you're drawing attention to the width of the curb cut. And I believe they're shown as 40 feet wide, which is right. Is that correct, Mr. Catrona?
That's the dimensions that we
Yeah.
have at this point.
So 40 feet is a wide curb cut, which arguably maybe wouldn't be allowed. So it's kind of like leave well enough alone. I don't see how this place will operate if you have narrower curb cuts. Otherwise, driving over the sidewalk.
May I respond to that there?
Yeah, go ahead.
In many cases here, I happen to know the owner of this property. I trust his word. Basically, that there was no physical changes ever, made to the conditions that are there. And when we have cases that predate 61 or zoning, and I could illustrate, not that we need to do it right now, but a lot of facilities that have curb cuts that are along the whole prolongation of the frontage of the properties. And, they predated, and this is the way that these conditions existed, to go in and really look at, the legality of something that predated zoning is questionable. No changes were made here. My intention always to this board, and just my nature of the way I handle myself. I want things to be accurate. If I'm saying something, I want to be able to stand behind it. We'll make an effort to do this here. I tell you, I may ask the owner to potentially price having a licensed surveyor go out there and simply just shoot the curbs and the footprint of the building and not really get into a complete survey. I would want that flexibility as well. We'll make an effort to see, and if we feel comfortable that we're giving information that hits the mark, you know, we'll be able to do that. It's sometimes it's easier for a survey to do that there once. I don't know if there's any curves anywhere along that. So either I'll do it that way, or we'll do it our way if we can feel comfortable and stand behind it. And you know, we'll be back to the board on the submission date with that information.
Okay, thank you. Commissioner Shetta, did you want to say something?
No, I just wanted to like indicate that we're not like, if the board permits that, I'm not asking for a formal survey to like help the owner to save some expenses on the surveyor. Like I said, the board, I just asked for 5 measurements. I believe they're gonna take probably like half an hour on site, 2 points, 50 or 75 or 100 feet apart. 2 measurements from each point to each curb cut end, and then the width of the curb cut. That's all what I'm asking for. I believe these 5 measurements would be more than enough if they are done accurately and reasonably to like locate the curb cut with respect to the building and give a very good idea, I would say, about how wide is that curb cut. If you want to do a formal survey, that's your call. It's not ours.
Thank you. Thank you.
Okay, thank you. Vice Chair?
Thank you, Madam Chair. No, I'm not questioning anything. It's just that if this is an opportunity for you to have the record consistent with what's been, that's all. But if it's not required, then I don't see why we need to go down that road.
The road of a surveyor.
Well, specifically having to, I was asking about the legalization of the so if it's not something that we had asked for, I don't see the need for us to raise it. It's and I'm indifferent about the survey in this case because the curb cut it's something not what we had envisioned, what we had asked for or weighed in on.
Right. It was really just about consistency between real life and the drawings that we had talked about. Yep. And right. So, right. Okay. Great. Thank you. So let's just, before we go on more comments about that, let's go to the public. So see if there's any comments from the public on this.
So the case that we're currently discussing is 1069-27BZ. The address is 6702, 6724 New Utrecht Avenue, Brooklyn. If you wish to call in, it is 646-558-8656. You will enter webinar ID number 813-7238-1108 and the pound sign. At the next prompt, you will press the pound sign. Once you're in the Zoom room, press *9 to raise your hand, *6 to unmute to speak. If you're in the Zoom room already, please raise your Zoom hand.
Okay, so, sorry, so Mr. Catrona, I think you wanted to add something?
No, I think I'm good, Madam Chair. I'm fine, yes.
Okay, any other comments from commissioners? Anybody? No? Okay, so, so we're going to put this on for a hearing in December, which would mean a submission either the end of November or like the first week in December. I'm just not sure what the hearing schedule is. So, okay, so I don't see anyone calling in. So we can close the hearing, I'd say. So I'd like to make, a motion to close.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shetta? No, can't hear you. Nope. You're muted.
Now you're muted.
One more time.
Now,
There you go.
One more.
Commissioner Sheet, is something covering your microphone?
no,
Oh,
There we go.
There we go.
Perfecto.
Say it. Now
you're
say.
back. You're back
it's
now.
time, probably it's time lag. Yes, I vote aye. Thank you. And I apologize.
That's okay. Commissioner Shabeta?
Aye.
Okay.
Thank you, Mr. Catrona.
So just to clarify, because this is, we're going to follow up on Darrell's cases. So we're giving him 4 months to make he's submitting the November submission for December hearing.
For the December hearing, yes.
Right, because the December hearing is the 5th.
It'll be photographs of the completed work. And also a dimensioned site plan. We shouldn't have closed when we said this, but anyway, okay, and a dimensioned site plan.
Okay.
However, it's dimensioned from whatever source.
Okay, great. Thank you.
Thank you.
Item number 27, 16949BZ, 5270 Amboy Road, Staten Island.
Okay, again, if this is your case, please raise your Zoom hand. I don't see Mr. Rampula in the waiting room.
My phone, I know I wasn't feeling it. Let's just see. Shoot.
It's funny that people aren't ready. What should we do?
She's gonna check to see if someone's stepping in for him. Because as I said, I know he was, for recent communication, he's been home sick.
Oh,
She thought he'd log in from home. Sorry, I don't mean to put his personal business out there. So-
okay. Maybe he has like laryngitis. We all know what is possible. So maybe, you know what? I don't want to stress him. Let's just put this on for call when he calls in right after the next case, because the cases will move quickly. I don't think we have anything that's.
All right, because she said to hold on. All right.
We're going to just put it on for the next one. Tell her not to rush, okay?
She put me on hold. Sorry.
Okay, that's fine. So let's go to 28.
Okay. So we're calling item number 28, 82755BZ, 245 139th Avenue, Queens.
Okay. Okay, at least we have the hands up. Okay. And Mr. Stewart also.
Yep. Hi.
Okay.
Okay, let me just swear her in. Raise your right hand. So you affirm, tell the truth, the whole truth, and nothing but the truth in your testimony before this board, to respond honestly to board member questions.
I do.
Okay.
Thank you. Elise Fullader from Merrick Palatnik PC on behalf of the applicant. I'm here with Andy Stewart from High Point. First is the operational plan. There was a change of staff at BP and we had to get it approved. It's been approved so we could have that submitted this week. So sorry for that hold up on the operational plan. And then the other question was about the trash enclosure. I can see Tony on the phone, so it's a little distracting. The trash enclosure, and the site is really small. So I have Andy here to speak on the feasibility of that. I think it would be pretty difficult, but he's here to explain further. Andy?
Yeah, so as noted by some of the board members, we don't believe it would be feasible to install a trash enclosure only because the limited nature of the site. The area that's striped there is only approximately 6 feet wide, which is big enough for the dumpster to be staged in. But with the bollards there, which were a previous requirement, and just the general site setup, we don't feel a trash enclosure would be feasible. It would only be facing the service road. There is the wall at the back that's blocking view of it from any residences. So I think what we're showing here is the best we can do with the constraints of the site.
I think there was a suggestion to wrap the wall around 139th Street. What about that idea?
I think that would be difficult only because with the wall, with the footing that's required, that small area, we have a light post that's there, we're putting in the bollards. I don't think wrapping the wall is going to add too much to it. You only have about 13 feet along that one line, and it's still for the most part facing the service road with the orientation of the site. So I don't think that's viable or even required. So.
Well, required.
Well, we don't feel, but.
I don't know, but required it, the board always tries to make the sites look better for the community. So
Yeah.
it's not like it's in a building code anywhere, right?
Right.
But, okay. So in the discussion amongst the board, people were concerned about like how this would look in the future. So what we could do is just alert the future board to be paying attention to this. And so, in other words, how's it being maintained? How is it attracting rodents, whatever, right? And that way, the next version might say, you need to put some kind of an enclosure around it, right? I'm just curious. I think when Commissioner Shabeta had suggested what he called the board on board solution, it's really not something that would need footings. It's not something that, it's more like installing even more like a residential box into which you put the box. But at least the public doesn't have to look at it. So that was more the concept. I don't know if those are made. So this is a roll-in dumpster, right?
Yeah, yes.
So, in a certain way, it's almost like saying, go buy one of those sheds and put the shed there and roll the dumpster in and then shut the doors. So that doesn't require any kind of a footing. It's just you go to the local whatever and you buy a shed. You know what I mean?
Yeah.
So
again, I just think it would be difficult to me to put that in, and it's a small site, maintain it, like you said, maintain whatever you put in there in a better nature. I think it's just with the fact that it's a rolling dumpster and the constraints of the site, I think just having it like this with the striped area would be better for, I guess, site operations, just easier doing everything like that. So, but so if the board's okay with it, then.
Okay, let's hear from other board members, because this was a subject and it is right there on the street. So anybody have comments about just leaving it as is versus maybe a shed or I don't know what? I see Commissioner Ollie Brown nodding her head as in you're fine with it as proposed?
Yes, I do. As I noted before, the site is very constrained, and where the dumpster is largely facing Conduit Avenue, which is a major commercial thoroughfare and a sub highway for the Belt Parkway. So I'm fine with it.
Okay. Anybody else want to add anything, or we're all?
No, I had flagged this, so I should to be on the record. I think. I haven't been to the site. I'm only basing it on the site visit from the photos that's been provided. So I am familiar with that Conduit Avenue frontage though. So, I think best would be to accept the recommendation that you're making, Mr. Stewart, but let the future board be on alert and be watchful, and should at some point a change or a need is or an improvement is needed, then the future board can take the decision at that time accordingly.
Okay, good.
Is that okay?
Yes, that'd be fine. Thank you.
All right, so let's go to the public.
Okay, the case we are currently discussing is 82755 BZ 245 139th Avenue, Queens. If you wish to call in to speak on this case, dial 646-558-8656 and to webinar ID number 813-7238-1108 and press the pound sign. At the next prompt, you will press only the pound sign. Once you're in the Zoom room, press *9 to raise your hand, *6 to unmute to be able to speak. If you are already in the Zoom room, press your Zoom hand.
Okay, so while we wait to see if anyone calls in, how much time to submit the operational plan?
It's been approved. It just needs to be signed, so I could do it in the next 2 to 3 days.
Ah, okay, so like basically 1 week to submit, is that
Yeah.
right?
Yes, perfect.
Submit, and it's only the operational plan, right, everybody? That's all we're looking for? Just want to check that I didn't forget anything. Okay, all right, I don't see anyone calling in from the public, so we don't really have any substantive open issues, so I'd like to make a motion to close.
Sorry. So this is 82755 BC. Chair Perlmutter, the motion to close. Chair Perlmutter.
Aye.
Vice Chair Chanda.
Aye.
Commissioner Otley Brown.
Aye.
Commissioner Sheta.
Aye.
Commissioner Shabeta.
Aye.
Okay.
Thank you.
Okay.
So I still don't see Mr. Rampula called in, so we can keep going.
I did speak to Peter Rampula. Mr. Rampula is still ill. Vin Roy just emailed you the app. He also stated to me, I was asking him to please appear for the applicant. He said that on 16949 BZ 5270 Amboy Road, Staten Island, they were withdrawing the application. So that gives me a little pause. Wasn't this an amendment?
Yeah, I don't see how
Part of the
they
amendment.
will. Unless it's a change in ownership and they don't want to continue under the same application, but how do you withdraw? I'm not sure what we'd have to look at that, right? So I tell you what, let's put this on for tomorrow.
Okay.
So that we can figure out what's going on. And because if they want to withdraw, we need to see that it's not something that requires a continuation, right?
Okay, absolutely.
In other words, an extension, okay?
Right.
Okay, thank you.
Okay.
So then we can continue as we've been doing.
Yes. So item number 29, 467, I'm sorry, may I go on, Madam Chair?
Just 1 second, okay, 1 second. Yeah, go ahead.
You good?
Yeah, go ahead.
Okay. Item number 29, 46758 BZ, 17211 Northern Boulevard, Queens. This is Daniel, I forgot his name. Daniel Ash, thank you. Mr. Ash, are you by yourself?
Yes, I am.
Okay, please raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to the board member questions?
I do.
Okay, please proceed.
Thank you, commissioners. I listened to the review session before. I've not been the person from the very beginning of this project, so I won't pretend why originally we did not have the sound readings. But I was on the last hearing, and it was my belief that you were looking for us to further clarify by having the sound readings with the ambient. So that is why that appeared on the drawings. I apologize if it's extraneous or if it's something you weren't looking for, but at least it did show that the sound was not excessive with the air machine or the vacuum machine.
Right.
As for the lighting, I think it always was, maybe the point was where we were showing the readings from, but it was never 0.1 from what I saw going back to the old submissions. The lighting is very low on that side, is 1 or 2. The lighting on the other side of the property.
I don't know, let's slow down a second.
Right.
If you were to compare your last submission, not this most recent one, if you were to compare the last submission to the current one, your last submission, oh, wait a second, now I'm even looking at the.
I'm putting on the screen.
Yeah. So, oh, sorry. Yeah, put it on the last. What happened?
This
Oh,
is,
here we
this
go.
is the last one.
The last one, thank you. The last one is in decimal points, right? And if you look to the right of the location, you have numbers like 0.7, 1.0, 1.5, 1.7, 1.3. And then at the very end, it's 11.2 and 3.4, okay? Which are the ones that we're really interested in, because when you look at the most recent submission, you no longer have any decimal points. It's 1, 1, 2, 1, 1, 1, and then it says 9, 32, and 28. So that's really confusing, because the last time you did this measurement, it was 2.7, 3.4, and 11.2. So, yeah.
What happened, the most recent measurements are with the lighting removed on the side of the building and with shields placed on the lighting, the one light on the corner. And
it went up.
Yes, because now we're directing the light at our property. Our readings are only being taken on our property. And because we shielded that light, it's now brighter on our side.
Yeah, but so then how does it drop down to 0 if it's 32 at your property line? You need to go, you need to measure it 5 feet off the property line or towards the neighbor in order to persuade us that you don't have 30, you don't have, let's say, 28 on the neighbor.
So I wasn't sure what we were allowed to do on someone else's property. We have to get their permission to go on their.
Well, not necessarily. You can also like use a broomstick and just attach your thing to the broomstick. But
I will also say that we will never achieve 0 for their side. We need to have some light on our property. This is parking area over here. We've already shielded it, so we're getting as best as we can. I don't think they would even want to have no light in their driveway on the other side.
right, but this is what's so confusing about your measurements.
Chair, please.
Yeah, go ahead.
Yeah, I hear we're talking about shielding. When you say shielding.
Oops, shit. Sorry. I didn't mean to do that. I hit the wrong button.
That's okay. Do you hear me now?
Yeah, sorry.
Yeah, when you talk about shielding, are you talking about the light pole or you're talking about shielding something else?
The light pole, we put metal shields on 3 of the sides, so it would direct the light so there wouldn't be any spillover behind or to the sides. It's directed down now.
Are you talking about this light pole, this
Yes.
specific one?
Yes.
I don't see like.
You're not seeing on this photo. This photo was taken before the shields are placed on.
Okay, now if we go back to the plan, you're saying that the 32 and the 28 and the 9 are on your property, right?
That is correct.
But these 3 readings were taken behind the light pole.
I don't think it's shown perfectly to scale on the drawing. That light pole, if you'll see from the picture, is on the property line.
Yes, but on the property line means, let me go back to the photo, means that you see that light pole is it's inside the property line.
Yes.
You look at the foundation here,
Mhm.
and the fence is kind of like 2 feet at the property line, correct?
Yeah, it's kind of the light pole is touching the fence almost.
Okay, what I'm getting at is if this is the case, the 28 and the 32 and the 9 readings were taken like downstream from the shielding. Let me use that language, meaning that it's factoring in the effect of the shielding on the light pole. That means that if you go further beyond the adjacent property, you cannot claim that the shielding will have any impact on reducing these lumen spread significantly. It's going to be the natural reduction. And if you look at the natural reduction or increase, which are way more or less the same, you see here you got 23 in all of this. Do you follow my cursor?
Yes.
Yeah, in all of this distance, you drop from 23 to 17.8. So this distance gives you just a drop of 6. If you're here and you got 32, that means that when you get to here, you're like 26. And in addition to that, I have 2 issues with, actually 3. Number 1, on the noise. I go back to the noise. We didn't ask for the noise. What we said last hearing is, I'm not sure why you're doing the noise, but if you want to put it before us, please separate it from the lumen spread diagram, meaning that submit it separately in a different plan. And this is still the offer for this hearing. We don't need it. If you want to submit it, take it to a separate plan so it does not confuse us. On the lighting, according to the notice in effect, the administrative notice, it says that lighting measurement should be done in 3 phases. Number 1, put the lights off. And number 2, put your lights on. By putting your lights off, you're gonna measure what's coming from the street lights, from the neighbor's lights, from everywhere else, except for your lighting system. And then when you put it on, you measure everything in addition to your lighting system. Then you do the math, you subtract 2 minus 1, so it gives us what's just getting from the lighting system on site. What I'm looking at on this very specific plan doesn't make sense for me. Why? Because if you look at on the front of this light pool here, at this distance, it says 23. But at much less distance here, it's giving me 32. That doesn't make, it can be. This light, if it's functioning right, it should shed lights that way, down, not up or in the back. The way it's presented now, it sounds like this light is doing the opposite. Or like the chair mentioned, it might be something like incorrect with the readings. I'm not sure.
I think it's more that the light here makes it appear that it's a couple of feet off of the property line, but really it's up at the property line where the reading was taken.
So you're saying they might be right below the light pool. That's what you're saying.
Below the light pole is where you're getting the 32.
If this is the case, I believe you need to take like some, and same thing for the 9 as well.
It's right to the side of it, yes.
Okay. I don't know what to say. Maybe, but I cannot judge.
Mm.
Yeah.
Well,
But you need to give like 3 sets or 2 sets of measurements, and then the third one, we call it the net lighting that's coming from your system. And I don't know why it's not done. It's clear in the notice. That description is very crystal clear. So
we were intending to do that. The operator, after we notified them we were coming on site and what we needed, did not have the ability to turn the light off. So that's why we only have with the light on. But I know that we're never going to be achieving 0 along there. So I'd like to hear what would be appropriate.
But it's so confusing. You put on a shield and your numbers went up.
It went up because it's directing the light. We're taking the reading at the point where it's directing the light onto our side.
Well, but even where it goes to 1.4, where you used to have 1, that's why it's so weird. Right, your numbers went up even in the low ranges. That's why it's so strange. Anyway, I don't want to belabor this. And Vice Chair has her hand up, so let's go.
I think in this particular case, given that the abutting piece of land that we are concerned about, the lumen spread, is a driveway. And we had, I think, a hearing ago, had also a similar situation where there was a little bit of a overspill of light onto abutting driveways, shared driveways actually of many properties. I am inclined to kind of let it be at this point, provided if the property owner, abutting property owner raises concerns about excess lumen spread affecting their activities, then the board should direct the applicant to take more draconian action and put more shields. But this is a driveway with very little light. I mean, I think this right at the edge, the amount of light spill is not that much. So what would fall on the side, on the driveway will also be much less. That's kind of where I stand. And I would ask the applicant to remove the noise drawings totally from the site, from the plan documents. You don't need to submit it to us. We didn't ask for it, don't submit it.
Yeah, I agree with that. The noise should be taken off. I think the comment last time about the noise was more like, it doesn't make any sense anyway, because of the following, just get rid of it, right? And we had this on another case where we told them to just get rid of it, and they did. And so that was the end of the conversation about noise. I would say, I know you're a new applicant, or let's say, new to this story. So if there's anything that you need clarified during the hearing, don't be shy, ask for it during the hearing. And if you don't, like you start to compute later and you realize, well, I didn't actually understand that, immediately call the project manager and ask for clarification, okay? Because it could save you and your client a lot of time and money, okay? So, and then what I do want to say, I do agree about the issue. I think we talked about this case where there was parking next door. So it's a less kind of critical in the window type situation. I think we were concerned because this is a pole light. And so a pole light doesn't just shine down onto the parking lot. It can potentially shine into windows. And that image that Commissioner Sheta showed earlier on was that there are windows right opposite the pole. So the shielding really needs to make sure that it's not lighting those windows. And that would be, a photograph taken in the dark. And then you easily see whether the side of the building is lit by that pole light. So understood that you want to have your own parking space lit, and that the neighbors wouldn't want their drive to be in total darkness, but they also don't want their window to be lit so that you can read a book in bed, that kind of thing. So what I'd like to, so let's go to the public and then we can talk about next steps.
So the case we are currently discussing is 46758 BC, 17211 Northern Boulevard, Queens. Should you wish to discuss with the board, dial 646-558-8656, enter webinar ID number 813-7238-1108, and press the pound sign. At the next prompt, you will be asked to press the pound sign. Once you're in the Zoom room, press *9 to raise your hand, *6 to unmute to be able to speak. If you're in the Zoom room already, please raise your Zoom hand. There goes the bottom of my screen. Great. It's one of those days today.
Okay. Got it. That was it. So now we'll wait to see whether anyone can follow those instructions and get into the Zoom here. Okay. So what I'd like to ask you, Mr. Ash, so one of the issues was that you submitted these photos that you called compliance photos, which show kind of how terrible the site looks in those photographs. So can you explain what the intention of the photos were?
So there was one line in our response letter that probably was overlooked because it's kind of throwaway. This was not intended to show full compliance or everything. During our last hearing, we talked about things that needed to get done on site, the asphalt repaving, some wall repair, and building a trash enclosure. We'd indicated that those items were going to require a permit, and we were hoping to get approval and then do them. And that the other items that we talked about last hearing, the planting and the lighting, could be done without a permit, and that we should take care of those right away. So the photo is to show you that the planting was taken care of with our landscaper. And the other photo was, there was a gentleman who called during the last hearing from the public to alert us that there was a porta potty put on site. I didn't know what it was at the time. I found out later on from the dealer that he thought that his clients, because of COVID, didn't want to go inside the station and would prefer to have a standalone porta potty outside. We told him to get rid of that. The photo was just showing that that is gone.
Okay.
We understand that there are things in that photo that still need to get completed, that we talked about as being a post-approval item.
Okay, so just to clarify, which I would like you to clarify in a submission, the things that for which DOB permits are needed are the trash enclosure,
Yes, and the wall repair.
wall repair, and the asphalt doesn't need a permit.
It doesn't, but it would only make sense to do that together with the rest of the work while you have the contractor. That's a big ticket item.
Okay, we'll need a permit or associated, sort of affect the others. Okay, so please, in a simple statement, state those things so that we know what's still outstanding. And then, let's see. I hesitate to say amend those drawings to take out the ambient, the noise.
One other thing that I apologize, I found out from my client on Friday that they would like to also add diesel to this site, which I know in the past has been something that directed back to the community board to give them an opportunity to see that change. And
What does that mean?
To add a diesel dispenser, one of the existing dispensers, to convert one of the dispensers to diesel.
To convert an existing dispenser to diesel.
Yes. So physically, you're not going to see much of a change. It's underground. The piping gets reconfigured, and the dispenser is going to now be able to dispense diesel. But I know it's been a concern that means more a long line of smaller trucks that would utilize the diesel, if that had any impact on.
So you need to show, you would need to show which dispenser would be the diesel and whether there's a maneuverability issue for the size of trucks that are going to go after that, right?
Yes, that's what we're intending to do.
Okay.
I just found out about this Friday before this hearing.
Okay, so submit a revised drawing showing with the maneuverability for truck types that would use the diesel. And so that's a question. Is there a limitation on the size of trucks? I mean, in other words, are semi-trailers like driving onto the site?
It's a pretty big site with the multiple entrances and exits. I don't think we'll have any problem showing a maneuverability.
Okay.
Large trucks would not use this.
Why not?
I don't think they would use that. Actually, I'm not positive. I'm going to look into that.
Right. So that's the thing. If word's out in the street, sort of that this is a diesel dispenser location, then all trucks will head there unless there's another way to get word on the street that you're not welcome if you're longer than X, right? So, which I don't even understand is there must be an app for this by now, but I don't actually understand how they could limit it. And then you have a problem if there isn't maneuverability. So you're going to have to show maneuverability of the largest potential truck that would need to pump diesel.
Okay.
Okay.
I would even suggest that you consult your, if you have a traffic consultant, you consult with them on what is the best dispenser to be like transformed from gas to diesel to make it easier for the maneuverability on site.
Yes.
And instead of like redoing the plans.
Right, instead of changing the layout.
Yeah.
Right, yeah. Thanks.
Yeah, I would think your most of the access would be from Utopia Parkway and Northern Boulevard, and you do not want these trucks to be navigating through 172nd Street. So that's another thing you should be mindful of the trucks not accessing too much of the residential street network.
Right. Yeah. So there are a lot of issues that come up here. And I mean, I suppose this may turn out to be substantive. I was hoping to close the hearing, but if it turns out after reviewing the maneuverability diagrams, commissioners are concerned about the impact or really the feasibility, then the hearing would have to be reopened. Is that okay?
Yes.
Is that okay with all the commissioners that we close in, but you may open? Okay. All right, so I'm just checking anything else because we didn't get anybody calling in. So please, on the drawing that has a noise readings, to protect you in the future, because the next board, when it looks at this, will say, where are your noise readings? Not knowing why they were asked for, but there they were. So take those off completely off the drawings. And if there's any further clarification you can give us on the lighting when you're doing that, that would be beneficial. But I just want to say,
if they can get us something from the neighbors on the lighting saying that they don't have a problem with it, that would be like a done deal.
yeah, that's true. If you can get the neighbor to say, yeah, we're fine with you put shields up already, right?
Yes.
That photograph doesn't show shields, right?
No. When we came back, it was dark when we were taking the readings after the shields were put up by the contractor.
Oh, so that photograph was taken before the shields were installed.
Yeah.
So can you provide another photograph showing the shields installed, please?
Yes, and also show you that the light doesn't go to the neighbor's windows.
Right.
Something in the dark for that.
Great. Okay. Understood? Everything understood?
Yes.
Okay. And again, if you have any questions when you start to figure out what it is you're doing, immediately call your project manager so that you're not like going down a garden path, a proverbial garden path. Okay.
Mhm.
Okay. Good. So I'd like to make so how much time to do all this?
Give us a month to have the updated drawings.
Okay. And anything else that's needed, right? And the responses, a month is enough?
Yes.
Right then, 1 month to submit. So I'd like to make a motion to close. Please.
Chair Perlmutter,
Aye.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Shabeta.
Aye.
Okay, so this is-
Thank you, Mr. Ash.
Thank you.
We'll let you know when the next hearing date is, okay?
Okay. Thank you, everybody.
Okay, so. I
Okay,
think-
we can go back to Mr. Rampula, who's been waiting.
Okay.
I believe still.
So item number 27, 16949 BZ 5270 Amboy Road, Staten Island. I think it's Peter's Rampula, but okay.
Okay.
Oh,
Good afternoon,
yes.
all. Sorry about that. How are you?
Hi, state your name for the record.
Peter Rampula.
Let me swear you in. Do you raise your right hand? Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board to respond honestly to board member questions?
I do.
Okay. So,
On behalf of Phil Rampula, apologies about today. He's been out of the office for a little bit, very sick. This is, of course, in reference to 16949 BZ 5270 Amboy Road. I'm looking at an email chain between Phil Rampula and Tony Matias, and it was in conversation about, from this past Friday, July 15th, it was in conversation about the upcoming calendar, looking to calendar this case for a hearing, and Phil had gone into detail about what's going on, looking to withdraw, and at some point during this email thread, the subject line appears for 2021-14-BZ.
which is the Starbucks, which I asked him
Yes.
about.
Yes.
So how did it
okay.
become Amboy Road, Peter?
So this was forwarded to me, and it was asked to prepare a draft for a withdrawal letter. So under my
Yes, that's what I
looking
asked
at
him to do.
this, I presumed it to be that Starbucks we were going to withdraw, and I actually had tried to reach out to Phil to speak with him, but he is, like I said, under the weather this
But
week.
I'm concerned about, this conversation's on the record and all it's doing is confusing all of us. I think what we had originally said was we didn't want this to be adjourned because we wanted an update on the
Understood.
status. But
Understood.
because you don't actually have the facts on the status and,
Right.
and you're relying on emails that are sent and you're not familiar with the case, I'd rather just call this an adjournment and you tell us how much time you need to get back to us on this case. It's been adjourned several times. It's been a long time since we heard this. So
Understood.
we don't like to keep cases just sitting there for what I think is a year, right? So we would like to put it on, if nothing else, for a status update. This was adjourned in April and September and heard a year ago. So something's going on, not clear. So perhaps if we were to put it on for a continued in, say, October, to give enough time to respond in some concrete way so we can understand what's going on. Because the last submission in September and the review session in September, we were satisfied with the application. And then we heard that there's going to be a new operator, not an operator, gas station, whatever it is, the company that supplies the gas. So what's happening? So how about that? We put it on for October to get an update on what's happening, because we can't, with it on the record, you not know, and depending on emails without your, it's not fair to either you, Mr. Rampula, or the owner, most importantly. Okay.
Understood. Okay.
Okay. So we're not gonna go to the public because this is effectively adjourned. Okay. So, and I'm gonna write October here, and if that works, depending on the hearing schedule, maybe November, but October is the ideal. Okay.
Okay. All right. Thank you very much. Sorry about this.
Okay. Thanks.
That's okay. Thank you, Peter.
Best wishes to Mr. Rampula.
Thank
Speedy
you.
recovery.
Appreciate that. Thank you.
Okay, moving on. Item number 30, 52358 BZ 11730 Farmers Boulevard, Queens.
Mr. Patron. Oh, he's not in the waiting room. Please text him again. Oh, there he is. You don't have to text him. Sorry. Speak up when you're there. We didn't see you.
Sorry. I got in and then I saw that Rampula's jumped in, as you were letting them, and then I pulled out and came back again. So here I am.
There you
Okay,
are.
raise your right hand. Sorry, Madam Chair, I didn't mean to interrupt. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions?
I do. Good afternoon again, Madam Chair, Vice Chair, Commissioners. I'm Glenn Catrona, representing the people over at 117 Farmers Boulevard. And I happened to attend the executive session, and I heard everybody loud and clear. In the past, I've heard comments like a strong good faith effort. I will tell you, from my perspective, we can drop the word strong, but I would say that the operator of this facility definitely made a good faith effort. Things are not picture perfect, but prior to submitting any sort of photographs, they had removed, at the request of the vice chair, the air pump at the corner of Baisley and Farmers Boulevard, and he sent me a photograph that was removed. And once it was removed, the pole that it was mounted to was rusted out behind, and I says, please paint that. And, you know, there was some pushback because they made some efforts and a couple other things where the vacuum cleaners were removed. Again, I had asked them to please clean it up. They removed some signage off the front because we went back and forth on this here because of the two different uses we have since, and there was no comment regarding the signs. I don't want to go there per frontage, but they removed the sign so that we were in compliance, and there was no paint behind the sign. And that was another thing that I made a comment on, and turned around and they did what they needed to do. I will go from top to bottom here based on what I had seen. So there was a comment, Madam Chair, you made about the plantings, and the plantings, couple of things on the plantings. One is that the plantings along the western property line did not continue outside of the fence line. Well, my plan since day one did not show plantings from that area out towards Baisley Boulevard. This particular project under the prior extension of terms was approved with an opaque fence. And this board had said, look, we want plantings, and went back to the owners. Of course, there was some pushback, but my plans have been very consistent since day one, showing it there. The other thing is that we know that a gas station is required to have one active air pump station, and that air pump station happens to be located, if you look at our plans, in that corner. Also along that fence line is 3 of the clothing bins, which we have discussed before. I don't see any way that we'd be able to do that. The secondary one was the vegetation and the flowering, planting of plants and vegetables, which is what the operators' employees wanted in that area. And when they finally got these plants in, they were past the date of being able to plant any kind of plants effectively back there, so they just didn't do it. Our issue with taking the pictures to show the entire length of that there was to show that we have consistently documented that the operator had installed the arborvitaes at 4 foot on center running down that corridor. As we had said, you know, all the vacuums were removed. The air pump, because of the potential of the hose that was sitting on the sidewalk in some of the pictures that we had sent before, was removed. The garbage enclosure, the trash enclosure was built contrary to my plans. And my plans that were submitted for the last submission reflected what was built in place, the chain link and the privacy slats. During the executive session, you were discussing the concrete with the steel doors. My plans throughout showed the board on board, the wooden enclosure, which has, in my mind, been acceptable to the board previously. And if I missed something with the concrete, that's always been on my plans, but it was never a comment that was brought up.
Okay, you're going a little fast, so now I'm trying to catch up to you just so far with the trash enclosure. So BSA 1.4, and there's a detail sheet 2.5, I think.
Yeah, please don't look at my last submission, because we updated the submission to reflect what we ended up seeing constructed in the.
Oh, okay.
But anything prior to that showed the board on board, which has been pretty much an industry standard. I mean, anything outside of BSA that we do trash enclosures.
Okay, so we have a 4.6 submission. Yeah, that's where, right, that's, I guess, why I was confused. You had new 8-foot cedar picket trash enclosure. So when I saw the recent submission, which was chain link, then I just went to my standard comment, which is why is it chain link? We would like to do masonry. I don't think the board was objecting to you doing the cedar picket trash enclosure because it's a real enclosure that's closed, right? The issue is that it's closed. So there wasn't an objection to that, but then there was a new version, a new submission. So that's the first thing. And then, and I know you were continuing, but what was the reason for not being able to do planting along that property line after the vegetable garden?
Sure. So as we go north on that property line, which let's call that the western property line, our plans have always showed, again, the prior extension of term and prior to that as well was an opaque fence. And then we were asked to provide the plantings. And we got the owner to provide the plantings, but my plans have been absolutely consistent as we move north up to where that existing fence line is, because right outside of that fence is where they park. The air pump is in the corner of the building there. So they use that to get out of the area of circulation. They pull between the clothing donation bins, and that area, that's a paved area. That's where they go to fill up their air, especially now that we removed the second air pump that's located on the site. So that air pump was, just to be clear about that was removed was by the ID sign at the intersection of Farmers Boulevard and Baisley Boulevard. So if you're going into this here facility to get air, you have to pull into that area. But in any respect, we never showed proposed planting there in all of our submissions. And we can see that there's some history here on this here particular project, but that's been the consistent condition throughout. I mean, I am actually, if you look at it from my end, and again, not to defend, applicants, but we do communicate very clearly with I would imagine, I know I do, with the people that we're working with. And, there sometimes is a difficult client, but I really feel that this here client made, some real substantial effort to make these changes. Just historically from day one, the first round of improvements that they made was to really reseal all the asphalt, repaint the buildings, repaint the canopies, upgrade and clean up. But that was just the initial part of it. So if I look at it from his perspective, they have been making slow improvements. Look, the acoustic fence in one area was done with the holding clips that I guess are supplied. For whatever reason, they went over the fence and connected, which doesn't really look clean. It's somewhat sloppy looking. I can't argue, I can't sit here on this side of the computer and look at each one of you in the face and try to push this here. I would like to maybe establish, what improvements that were made that are, sort of not acceptable, and maybe go take another bite at the apple and see if we can get it yet a little step further. But again, truthfully, from this end, going on and on, they made some efforts. They were reluctant, but they made some efforts. They rose to the occasion. And I can't, like I said, I can't argue that this is picture perfect. But in any respect, I think that the trash enclosure seems to be, somewhat of a different level of some of the other comments that were made. I mean, if I have to tell them to rip that out and rebuild it, and Madam Chair, you made a comment, or I believe it was you, that that there was a trap adjacent to that. Well, I'll tell you what. I mean, I went to Costco yesterday and had to walk over one. They're all over the city, and I'm actually happy that they're trying their best to mitigate any kind of problems, because it's prevalent in New York City. But we don't try to stage the photos. We go there, we do the best we can to document the improvements that were made. If you ask me my opinion in terms of the quality or whatever, I'd rather be reserved about that. But in any respect, I think we're talking about potentially asking for certain improvements here on this here so that we could finally get to close this case out.
Okay, let's go to the vice chair, and then we can talk about the degree of stuff. Okay, go ahead.
Thank you. Yeah, I am looking at the earlier submissions, and Mr. Catrona, you are right. Like in your drawings, you have not indicated extending the planting along the western lot line. It was always from that fenced area up and then moving south. My question with regards to planting is along the remainder portion of the southern lot line, which is supposed to be all at grade planting. And the photos that were submitted do show at grade planting up to the inside of the fenced area, but on the outside, that what is being shown are a couple of plants that are on planters, not even on the bed of they're not planted in ground. So I think if any place we need to have more robust planting, it would be along that frontage, given the proximity of the residential use. That's my suggestion, Madam Chair.
So sorry, you're talking about the southern where light parking spaces 7654 are? Is that what?
Yes. So if you look at the photo, for example, I just saw the photo, photo number 30. You do see the in-ground planting along the southern lot line, and then there is a paved area on which planters are on boxes. On planters, I'm sorry. So I think per plan, that area is supposed to be all in-ground planting.
Yes.
And am I wrong?
No, I'd like to respond to that. You're right, but it's actually that photograph probably shows there's about a 12 to 15 foot slab that exists there that's embedded into the fence line and all of that there. That outside of that fence line most certainly is planted, but there is that section of concrete where they actually put the plants in planters. Along there, there's about 5 or 6 plants there potentially, maybe not 5, 4 to 5 plants that are there. And we observed and photographed them. That was a condition that they had installed in that respect.
Okay.
Just a few of them. It's not that whole line. It actually is planted at the street line and at the fence line. And as we get to that port, it's just a small area where they did not remove the slab.
Okay. So in your next submission, if you can just provide more detailed photos of that. So I appreciate the work that you've done then. It's just not clearly coming through in the submission.
I mean, so that's part of it. You know, if on a drawing it says there's a footing or something like that, which prevents in-ground planting, and then say what you're going to do instead, because the problem with drawings that show something different from what is actually installed is that the next time you come to the board will ask, why didn't you do these things, right? And then you start all over again. So the drawings should really explain what the field conditions are and kind of why they have to be that way. For example, I didn't know that about the air pump access. So, you know, you could say, you know, planting not possible over here because they need, there's a maneuverability issue, and you would show a car that moves in and out for the air pump or something, because you're going to end up having this conversation, or the next person who comes before the board for an extension will have a conversation about why it's not happening when it's sort of so obvious that it should continue.
I appreciate that. I appreciate that, but let me just respond. So, yes, again, the portion along that property line, we never showed the planting. My intention and my drawing showed what we believed was going to be the as-built condition. Okay, so it's the adverse. We expected the plants to be in the ground along the southern property line. Okay, and you know, right at the final hour of us being able to get this submission in was the completion of several of these improvements, and that's what we saw when we got there. So we're not trying to, put anything, not be clear to anybody. My intention was those several plants were to be in the ground, that pavement would have been removed. Okay, and the contiguous line of planting area in the ground would have been there. So we can document that. I mean, if it's unacceptable to the board, then I want to go back to our operator and just simply say that it's not acceptable to have those several plants, in a planting pot rather than being in the ground. But if it is, then I will go and I will measure it. We'll measure it and we'll document it and be very clear about it.
I mean, the concern always about those planting pots, as opposed to what I think I mentioned, it's actually, am I right? It's one of Mr. Rampula's projects. He had a condition where there couldn't be in-ground planting. So they created these excellent planter boxes and they're thriving. It's got really big trees growing out of it. And, that's a solution. Whether or not you have the space for that, I can't tell because I see how the cars are parked and where the fence is. But, those are better solutions than those trees are going to die in the first winter because there's no insulation on the pots, right? Those look like plastic pots. So it's not a permanent solution. It's more like, make the board feel happy in a photograph solution, and then you'll have a problem the next time. So I'd really recommend that you try to find permanent solutions for these things. And then that same photograph number 30, which reveals the wacky acoustical draping. I mean, you're saying, can we make a list of things that need to be improved? I think you know enough about the aesthetics of a site to know what's not going to fly. Obviously, that one doesn't fly. I think you've worked with the board long enough, and yourself, you have a good sense of what's, a proper installation. So like, for instance, you take the sign down, but you don't paint behind it. How could that be okay, right? So rather than us sort of lead you by the hand, which you don't need, I think really, unfortunately, you have to lead your client by the hand because they may just not be connected to that sort of aesthetic standard.
Madam
Right.
Chair, I'm clear. Thank you.
Okay.
I got it. I hear you loud and clear. So, yeah, there was another comment that was made about the bollards, that there was a car potentially parked there with no license plate. Well, we've discussed this before. They do work on cars of people that actually would sell the cars. They're not selling the cars. In fact, in a prior submission, it may have been 2 or so back, both the owner of the property and the operator signed affidavits that there will be no sale of vehicles on this particular site. And if you go back in the record, you'll see one from the owner, one from the operator.
Sorry. One from the owner and one from the operator, what?
Affidavits stating, they had prepared affidavits and signed, notarized, and we submitted prior submission. So, that's not the case going on there right now. It's just a matter of, I don't have any other explanation, but that they work on all cars.
Okay, well, we're going to make that very clear in the conditions, no sales. Okay.
May I ask, going back to the only thing that I am not fully clear about, some of the other conditions I can document and ask them to make certain improvements there. The trash enclosure. I don't know any trash enclosure that would keep rodents out of there. This is not a place where they have food. This is remnants of repairs from vehicles that they have. So I don't really see it as a source of calling rodents. I mean, at this point, it's an enclosure. It's not pretty.
Wait, before you go on. Normally, the enclosures are intended to shield residential neighbors from the trash, right? Both visually and to the and odoriferously, if one can say that, a variety of things like that. I see that the enclosure is located within a fenced area. So my first question is, can neighbors see this trash from where they are, or can the public see it from the sidewalk?
No, I don't think so. Because the way that that is actually a much lower spot, the way that the fence is at the property line. I don't believe so. If you want, I will eyeball it and be able to answer that with absolute comfort. I don't believe so. It's never been an issue. Nobody's ever complained that the trash was there. We relocated it to the other side. We ended up in a situation where just circulation on the site would have been compromised. So we asked to move it back there. We did move it back there. Again, our details showed what our details showed. It was built contrary. We simply recorded what was built. I don't believe it's an eyesore to anybody at that point. It's behind the fence and then yet again within a fence.
Oh, what happened to Madam Chair?
She put her finger up and then went out of screen.
Sorry, I need a couple of seconds. Vice Chair, you can continue this. I just need a couple of seconds. Can pick up from where we left off, okay?
Okay. You know, I was actually going to raise my hand to comment on what you said, Mr. Catrona, and which is, yes, typically we do ask, I mean, of late, the board has been asking for masonry wall with steel door enclosure, specifically in situations where the trash enclosure is a standalone trash enclosure and not sealed away or tucked away behind anything. In this case, you have a trash enclosure that is already behind a fence, behind another fence, which is opaque and slat. And this is not a place where food is made. So the kind of stuff that would be thrown, metal, God bless those rodents who are going to chew into those metals and rubbers. We're going to have like super rodents, ninja rodents or something like that, maybe. So I think I would be okay with it, but I know this was a concern raised by some of the other commissioners. I would like to hear from them. I don't think if you can just clean it, just simple cleanup appearance, making all the slats look perfect with no gaps or anything. I think those are the things that would go a long way. And I think Madam Chair is right. We don't need to handhold every bit of everything that you're guiding your client with, but you know what we're looking for. And as I'm looking at the photos, you know, there isn't any windows that is looking, at least from the residential one, I'm looking at the building that is to the south, does windows that onto that portion of the lot line.
There is
so
one.
I would be okay with it.
Yeah, there is only one, and that
where
one of the
although where we have
where the acoustic fences actually Commissioner
that's
Shetta
cool,
had asked
right?
for that several hearings ago, and that's
okay. Okay, yes, you know, thank you for reminding. Yes, there is one. That's why we had asked for the acoustic block to be put. Yes, I'm sorry, I take it back.
So if I could speak, I was one of the commissioners who had raised the issue. And I think what I want to say is that garbage enclosure, and please excuse my heavy breathing, extremely anxious dog, because we are in the middle of the thunderstorm right now. So he's like panting like a crazy man right by my feet. But anyway, I was the one who said that garbage enclosure was problematic, because to me it's like symptomatic of the haphazard way in which the site conditions have been addressed. And so while I understand that there's probably only one window that's actually going to be viewing the garbage, and you could persuade me to let it just stay the way it is because there is no food waste going into that garbage, probably that rat box was just haphazardly kicked over there and probably should be in the enclosure. But I think, like the chair and the vice chair have suggested, that you need to do a once or even a twice over on this site. Take a look at it from all angles, and also imagine that you are the homeowners behind the fence and what they're actually looking at, and try and make this a site that is not an eyesore, that's not going to make them want to draw the blinds all the time because they don't want to see outside of their window. So that's what I would say.
Yes. Right. Thank you. Appreciate that. Sorry for that break there. You know, that's the underlying theme. Imagine you live next door or walk by this every day. What would you want to see if this was your neighborhood, right? And that's always the theme. And I know, Mr. Catrona, you know this. We don't want to have to explain to you kind of what's really obvious, right? Okay, so I'm sorry if I missed what the vice chair had instructed. I'd like to close this, but I would like you to make those improvements based on you walking around with your client and saying, this isn't okay, change this to this. Don't just tell them it's not okay, tell them what exactly they have to do to improve it. From the point of view of the trash enclosure, either demonstrate to us that no one can see it as done, or put it up the way it was shown to be on your drawings, your previous set of drawings. And then, yeah, all those other things that look pretty shabby, right? Unshab the shab is really the.
I'm actually writing that down.
Okay. And if it's not a verb, it should be, right?
Did we already go to the public, Madam Chair?
Oh, I don't remember. Did we? Does anybody remember? No, okay.
No, we didn't, right? I thought I lost my train of thought there, but no, okay, we didn't. Okay, good.
No.
Okay, thank you. So let's go to the public then, right?
Mhm. Yes.
Can we go to the public? Yes, all right. So the case we're currently discussing is 52358 BZ 11730 Farmers Boulevard, Queens. If you wish to discuss, dial 646-558-8656. Enter webinar ID number 813-7238-1108. Press the pound sign. At the next prompt, you will only press the pound sign. Once you're in the Zoom room, press *9 to raise your hand, *6 to unmute to be able to speak. And if you're in the Zoom room already, please raise your Zoom hand, and it's only for 52358 BZ 11730 Farmers Boulevard, Queens.
Okay, so because so I always use this time to discuss how much time, right? So because this is a combination of coming up with solutions, for instance, for the planters to make it a permanent solution, the shab solutions, and then persuading your client to actually do those things and then follow your instructions, how much time do you think you really need for this?
Probably 6 to 8 weeks.
Okay. Whenever it's offered, I always go for the bigger one. So I'm writing 2 months to submit, right? Is that okay?
Yes.
Okay. So, all right. So then I don't see anyone in the waiting room to speak. So, yeah.
Chair, I'm assuming if any of these changes require revision to the drawings, those also would be made and also reflected in the statement of facts. Excuse me.
Revisions in drawings. And in terms of, again, going back to the plantings on that southern wall and on the, whatever that one is, the western wall, property lines indicate why there's no, the planting has to be above grade in one location and not at all in the other. Indicate that on the drawings, okay? So in future, no one's expecting it, okay? And when I say expecting it, that the future board might say, I don't get it. Why isn't there planting here? We know it's not on the drawings. Give it to us, right? Okay.
Good. Want to still, oh.
Okay, so then I'd like to, so we said 2 months to submit. What did you say, Tony?
Commissioner Sheta?
Oh, I'm
Yeah,
sorry.
thank you, Tony. On the trash, I just want to make sure that we're on the same page, all of us. That he's gonna provide a photo to like prove it to us that it's not visible from the adjacent property. Is that what we talked about?
Which what? Which that?
That trash enclosure.
No, it's not about not visible, right? So I don't know if he can enter the adjacent properties, but from the street, it
No,
can't.
the opposite. Take a picture from the subject side to the other window, and if you can't see the window. Personally, I'm okay with the location. I did look at one of the Google photos, and I believe the current location of the trash enclosure is clearly shielded. If you look at the windows, like to the north, I believe, if I'm not mistaken, I believe they cannot see the location. If you look at the one direct window across, I believe there is a big tree that can shield the trash enclosure from being seen from the adjacent property. I just like don't want the applicant go bring something and then we start discussing it one more time. The way they gonna prove it to us that it's not feasible from the other property is by taking a picture from the subject side or how?
Yes, that makes sense. Okay. I'm sorry. I thought you said the word feasible. It's the word visible. Okay.
Visible, sorry.
Right. Okay.
Forgive me, sorry.
Okay, so you got that, Mr. Catrona, that makes sense. That's an easy way to tell whether it's viewable from where. And that's how we decide whether it needs to be, that's how you decide. Because we're gonna close this and we don't want to have a back and forth anymore. So if it's visible, you have to change it to the nice enclosure. And if it's not visible, it's already hidden behind a fence from the street and not visible to the windows next door, right? And behind. Got it?
Yes.
Good idea. Thank you, Commissioners. All right. So I would like to make a motion to close.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye. Sorry, aye.
You okay? Commissioner Hartley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Okay, we closed. Okay.
Okay, thank you.
Appeals calendar, continued hearing items, item number 30. Oh, I'm sorry, Mr. Catrona.
Appreciate everyone's time. Thank you very much.
Sorry. Item number 31, 2020, 67A, One Ballard Avenue, Staten Island.
Okay. And we did get fire department sign off on this, right?
Yes.
Is this Todd's case?
Todd's.
Yeah.
Okay, Mr. Dale. In? Hey, please state your name for the record and proceed. It's an A case, so no swearing in.
Good afternoon, Todd Dale for the applicant. So I did listen into review session and heard the comments that were raised by the board. I'll address them now and hopefully I got them all. I believe, Chair, you noted, as noted, the Chief Daley sent a message noting that the fire department had no objection, which was one of the questions that was raised. With respect to city planning, as you noted, a chicken and the egg situation, the property owners are agreeable to a condition should the board be ready to grant this application regarding the need to obtain any required subdivision approvals from city planning. And we expect that it will be forthcoming subsequent to General City Law 35 appeal grant. We are agreeable to, with respect to the ramp condition and the tree condition noted in the Department of Transportation letter. I believe Vice Chair noted that the BPP that was presented showed that the tree that's closest to the curb cut that's proposed is 7 feet from the curb cut as required by the Department of Transportation letter. But we'd agree to any condition in a resolution should be forthcoming that street trees or must be with outside or more than 7 feet from any curb cut. But we believe that that condition is currently complied with by the BPP, but we could have that added as a condition of the resolution also. The final key item that was raised was with respect to 72-01G and the bulk waiver. I guess what I would say is we're agreeable to whatever we need to do to resolve this, but not to belabor this or get too long in the history, but Staten Island's the only borough that issues this objection, and it started circa 2015. And I know previously when this first came out, Tony may remember this, but we worked with Becca Kelly, who was counsel at the time, coming up with general language, because the issue that was coming up for applicants is that the Department of Buildings would issue this objection referencing 7201G, and we would ask them, well, what bulk waivers do we need to request from the board? And they'd be like, well, we're not going to specify the bulk waivers. So then we'd come to the board, and Department of Buildings wouldn't tell us what the bulk waivers were. And it was left to the board and the property owner, the applicant, to sort of interpret what they'd expect the Department of Buildings might ask as far as bulk waivers. So we came up with generic language at one point, and I know that we included that in the statement. What I was going to say is we're more than willing to submit a statement. I looked at the original statement. I don't think we referenced 7210G, but we can submit a revised statement referencing 7210G waivers. I believe it would only be the 2 front yards and the floor area. However, since it's never in the history of 7201G objections been specified to us by the Department of Buildings, the concern we have is that we specify these waivers, the board specifically references front yard and floor area, and then we get to the Department of Buildings and someone raises an issue about height or something that we wouldn't necessarily have thought of. So I would say we can include the general language that we historically included. We can reference more specifically the front yard and floor area, but I would just suggest or perhaps have some sort of discussion as to a way we can make it a little bit more general, just in case something is raised as a surprise by the Department of Buildings. And I'm just going to throw one more thing onto that recently.
Question. Okay. Why is it floor area?
Because we're proposing area that's in the street, and the question is that can you use the floor area that's in the street before the general city law 35 waiver? It may not be the floor area, but we were just trying to think of anything that's part of the confusion we have here, is that it's never been specified by the Department of Buildings, and we're trying to guess what they might come up with as an objection. But I just want to throw one more.
Okay.
So one more bit to this is that, as I noted, Staten Island was the only borough that would issue the 7201G objections for the general city 35 law appeals, and it started circa 2015. Recently, though, our office has filed 3 or 4 applications where Department of Buildings has not included. They've stopped including the 72010G application. So we actually have 2 that are pending before the board that have not yet been assigned a hearing date, where those objections weren't included any longer. So I don't know if they're phasing this out of their policy. The short answer is we're happy to do whatever needed. Our primary concern is we don't want to seem to be a difficult applicant, but our primary concern is we don't want to come into a situation where we're a little bit more specific with a bulk waiver, and then we get to the Department of Buildings and they come back and say, you should have mentioned height, you should have mentioned something that's not there. So I don't know if there's more of a generic or a little flexibility we can add in the language.
So not too many people actually have asked for these waivers, and it seems to have not mattered. At the very beginning, when we were doing this, in the last, say, 6 years ago, we started to have problems about blanket waivers, because people were thinking, oh, that means I get a side yard waiver and a rear yard waiver when the building isn't even sitting anywhere near that part of the zoning lot, right? So, and they were actually using it. So, so we said, no, wait a minute, it has to be something that's related to the bed of the street, right? And so maybe what we could do is be specific like that, rather than listing the waivers, say waivers related to the fact that whatever, what, is this the one that has 20 feet of the properties in the bed of the street?
That's the next one. This one, it has a portion. I don't know what the portion is off the top of my head. I think it's
But
like
it could be
12 feet.
something like waivers related to the portion, specifically related to the portion located in the bed of the street.
Sure. I mean, I would say waivers related to the portion in the street and the location of the map street line, perhaps adding that in also, because the yards are measured from the map street line. So
I think the old saying was something like that you would comply, be that for the bed of the map street, creating the non-compliance, something like that, wasn't it?
Hi.
Something like that.
Yeah. Chase, go ahead.
We include language that DOB shall review the plans approved for compliance with all relevant provisions of the zoning resolution as if the unbuilt portions of that street were not mapped.
Oh, did that work? That work to not require them to come back? So that sounds great, but I do remember one case in Staten Island where, I think this was Sandy's case, the house is sitting in the center of the road. And it gets bounced back to us because we didn't waive the front yard requirements specifically. And we're like, what front yard?
Oh, that was the mosque, wasn't it?
No, this was, I thought it was a house, but all right, maybe it was the mosque. Doesn't really matter. But
Or
it
something.
was kind of crazy because we didn't even know what we were waiving because where's the front lot line? I don't know.
Right. I might suggest, in light of the fact that since recently we haven't seen these objections and it may not be a primary concern to the departments of any more, if I recall, was it Department of Buildings to review for full compliance with underlying zoning as if mapped but on-built street not present?
Yes.
I would suggest that we can submit a revised statement. We'll include that we are requesting relief pursuant to 72-01G and include language to that effect in our statement. And then if the resolution is there, I would say that as an applicant and a property owner, we would be willing to go to Department of Buildings with a resolution if it's granted with that language. And we believe that under the current climate that it shouldn't raise an issue, but if an issue is raised, then perhaps a letter of substantial compliance could come for a specific waiver. But I believe that language, as Mr. Vine noted, would work. And so we can submit the statement requesting that and then get the standard language in a resolution condition.
Okay, that's great. Okay, yeah, Vice Chair.
So we'll do that.
No, I was going to suggest that I think best would be between Mr. Dale and our general counsel. You kind of iron out the details of the wording and the sentence. And once both of you are okay with it, why don't you put that in your statement?
Sure. So what I will do is
good for to discuss it.
Off the record, I will submit a draft of the statement to Mr. Vine and the project manager and get any feedback on this. And if it's good, then we'll officially submit the statement and then a condition can be forthcoming.
Okay, perfect.
All right, we'll do that.
Great, thank you. So the only thing that you didn't mention, which I don't know if it was on the BPP, was the sidewalk ramp upgrade that DOT requested.
When I spoke to the architect and project engineer, they believe that the ramp there, because there actually is a current curb and a current sidewalk, and really the only change the BPP is proposing is a curb cut. They believe that it is currently compliant with ADA and DOT standards, but we would be agreeable to a condition that pedestrian ramps adjacent to the property must comply with ADA and DOT requirements pursuant to an approved builder's pavement plan. We would say that perhaps the resolution could reflect a condition saying that they must be compliant and not saying they must be upgraded in case they don't need to be upgraded.
Okay, so it's basically just copying what DOT said.
Sure,
the applicant is required to upgrade the pedestrian ramps. Well, they're saying upgrade the pedestrian ramps as if there already is a pedestrian ramp to comply with ADA. So is there something and DOT's requirements. Is there something about today's version of a ramp that's different from what, 2 years ago's version of a ramp? I don't know.
I'm not the engineer. The engineer says he believes that these are currently compliant. That's why I'm saying if it's just a blanket resolution condition that says they must comply, and that way, if an upgrade's necessary, well, then we're going to have to upgrade. But if an upgrade's not necessary, they comply, and it's going to be pursuant to an approved builder's pavement plan. So I would say we'd agree to that language, but perhaps eliminate the word upgrade and just say must comply.
Yeah, I got that. Okay. Good. All right, good. Let's go to the public.
The case we are currently discussing is 2020 67A 1 Ballard Avenue, Staten Island. Should you wish to discuss, please dial 646-558-8656. Enter webinar ID number 813-7238-1108, #. The next prompt, you will press only the #. When you're in the Zoom room, press *9 to raise your hand, *6 to unmute to allow you to speak. If you are already in the Zoom room, please raise your Zoom hand.
Okay. So, do we have any submissions?
DEP?
DEP. Sorry, yeah, thank you. So, we did see, of course, you have that sewer connection sign off, but did you reach out as recommended by, I guess that was DOT that said about DEP having some kind of capital plan?
I asked the engineer to reach out and he didn't receive any comment back, but he said that if there were any such plan or issue, that the connection approval they had, it would have been flagged during that process. So their statement to me was they didn't receive any feedback from DEP specifically with respect to that improvement, and that they believe that the approval that was received is confirmation that there is no effect on this. So
that's sort of assuming the guys in one department talk to the guys in the other department, which we know doesn't always happen.
Right.
So what I would like to do is I'd like either Tracy or Tony to reach out directly with an email to DEP, referring to that DOT letter. Like you could say DOT submitted a letter to us stating that they believe there may be, it says here, it's the letter of October 15th, 2021 that says there's no capital project at this location, which has been canceled and so on. There is a DEP project SE 818 for sanitation and storm sewers in Sheldon Avenue between Ellsworth and Delmar. And we'd like to know whether this location would impact that project.
Okay.
Right. Sure. And if anything comes up, we can respond to it. I would say, though, that Sheldon Avenue, just the board is aware, because it might not be clear from anything we've submitted, is 4 to 5 blocks south of Ballard Avenue. So it's not in the immediate area, but we're happy to respond to anything if you receive any response from DEP on this.
Okay, it's just to clear it up because.
Sure. No, I understand. Yeah. So.
Okay. All right, good. So no people called in. So in terms of things to do, you don't have to do anything, right? It's just us, I think.
No, we'll submit a draft statement. Tony, were you project manager? I'm to the project manager and counsel on this, just to say, here's our statement. And with respect to the bulk waivers, and once we're happy that that statement is in line with any potential condition, we'll officially submit the statement. But that's all we need to do from our side.
Okay. How much time?
We could do that in 2 weeks. Less even probably, but I don't know if we want to have it a little bit longer, just in case you think there might be some delay in a DEP response.
Well, that's a little different. Your submission versus DEP.
How's it?
Different, right?
We can submit within a week on that. Okay. So
So, because the earliest you could be, I don't know if it's even possible, the earliest you could be heard is August. So that gives DEP plenty of time to answer an email.
What would be the submission date for that August if it were available?
This week, isn't it?
Oh, it is this week. Okay, so it has to
I
be
think it's this week,
September.
isn't it?
Okay,
Yeah.
yeah,
Sorry.
I don't have my calendar open.
Yeah, submissions for August 8th hearing is Wednesday.
So that's not gonna work, right? Or it is?
So
Wednesday?
perhaps the next hearing after that, let's set that, and then we can get, that'll give us a little time on the submission to narrow down any language you need and hear from DEP.
Okay, September here. So I'm just
So
gonna,
the September 12th hearing, yeah, okay.
I'm just writing September hearing, okay?
Yeah, and the submission date is the August 24th for September 12th hearing.
Okay.
Is the submission date.
Good. All right,
That would work for us. Thank you.
great. So then a motion to close. Thanks very much for your work. Okay, motion to close.
Chair Perlmutter,
Aye.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Oh, didn't hear you. Nothing. You're muted now.
Aye.
Yay.
thank you. Commissioner Shabeta,
Aye.
okay.
Thank
This is
you.
also a decision. Thank you. Item number 32, 2021 2A through 2021 7A. This is 9-21 Hollis Avenue, also known as 19101, 9, 13, 1, and 19205, 19213 Hollis Avenue, Queens. This is also a GCL 35.
And we also have fire department on this, right?
Yes, fire department, no objection.
Right, so Todd Dale again for the applicant. As noted, the fire department issued no objection. We did submit the DEP, or excuse me, DEP did issue a letter of no objection. Since we were on the subject with respect to 7201G, these lots are in Queens and there were no 7201G objections noted. If the board's agreeable to it, we are fine proceeding to Department of Buildings without any reference to 7201G because historically it's not been an issue in the borough of Queens. The other issue that was brought up, I don't recall seeing any letter of no objection from Department of Transportation on this, or if there were any issues to which we needed to respond. We did do some review of online information. It doesn't appear there's a capital plan, but depending on what DOT issues, we can respond accordingly. And the only other issue is with respect to the proposed sidewalk and the concern raised by the vice chair at the last hearing and this hearing. Just wanted to clarify that a couple of things with respect to the sidewalk. We did receive the diagram. Ms. Ebanks-Chu did provide that to us, and the project architect was limited what they could do with respect to the existing curb cut. We're not proposing to change the curb cut, but we are proposing to improve the sidewalk. Currently at the site, there's a very small sidewalk. It's only like 18 inches wide. The proposed development calls for a 5x5 foot flag, so the sidewalk will become much larger. The most recent proposed plan shows a shift of that sidewalk north by 1 foot, which was the option that was available outside the property line. The concerns that come up with respect to the diagram that the vice chair provided is that if you move the sidewalk any further north, it would enter into the private property of the property owner. And that then becomes a situation where if you're going to put a public sidewalk there, then the city needs to acquire it either through a taking or if the property owner was willing to deed that over to the city. But the issue then with deeding it over to the city is you run into a situation where we'd have to change the tax lot. We'd have to engage in a lot of other issues. We didn't even bring up the issue as if the property owner would be willing to do this. And then there's the concern with the proposed home right now is proposing an FAR of, I think, 0.57 per the zoning analysis. And if that were then acquired by the city, it would require reducing the size of the proposed home because it would no longer meet floor area requirements for the site. And I can say initially the property owner is reluctant at this time to consider that. So the short answer is that with the current property line and the private property, we did shift the sidewalk north as much as we could. And we, in consideration of the fact that also it's going to require a widening of the sidewalk to be the 5x5 flags as required by DOT. So we did try and respond as best we could within the constraints of the current situation.
I see the vice chair's hand up, but I just want to throw in this one little legal thing. Just because you, let's say, have an area that's used by the public, doesn't mean you ceded that area to the public, right? It's still private property, right? And what we see from all of those private parks, like up and down 6th Avenue or whatever, they just put a little plaque in the sidewalk that says this is private property. And actually, what I know they do just in case is once a year, they put up a little, I don't know, cleaning the sidewalk thing so that once a year, nobody can actually walk there. And that's their way of, I don't know how, but anyway, preserving private ownership. So I guess it has to do with adverse possession or something. I don't know that the city ever exercises adverse possession, but just a little plaque would say it's mine. And you could draw like something very clear, even have a different sidewalk material, so it's very obvious that this isn't yours, this is mine. So it seems like you could accomplish this without worrying that it's going to become the public domain. But Vice Chair, go ahead.
I see both your viewpoints, and Mr. Dale, thank you for clarifying that. Yes, Madam Chair is right. I mean, we do have this concept of POPs, and that gives you, and it is through a very legally executed information whereby you exercise additional floor area for providing that public space or that private place for public use. While I would love to explore that possibility wherever possible, I don't think we have that tool available here. So I understand your position. I though would request, if at all, is to extend that little hairline of that green thing you have along the property, just to make it uniform and wrap it around. It's just going to beautify your property. And it can still be part of it. You're just moving the fence one bit hairline inside, but your property will still be just up to that green space. You see what I'm saying?
Hang on, let me bring this up.
There is a little bit, if I'm looking at along the property line, you have this dotted piece of green space. I'm assuming that's a green space. And your property is a little bit in from it.
Are you I'm sorry to interrupt, but are you referencing the proposed plans that we submitted?
Yes, yes.
Okay, so I'm looking at the proposed plans.
Let me go to the, oops, why am I not looking at the, I'm sorry, let me go, oh, I missed it. My office setup changed a little bit, so I'm trying to. Just give me a second, my office.
While you're doing that, I have a question for Mr. Dale. I'm a little confused by the statement that you said. So the area that's on the proposed plan, right behind the number 1832 and 35.5, those are, there's that dashed line that indicates the property line, correct? So that's private property, right?
So 3550 and 1832, yes, that is the private property line, correct? So there is a public green space above the 35.68 dimension, And then the sidewalk then is proposed to be right at the lot line at the 35.5 dimension and the 18.32 dimension. Correct.
Okay. And your concern about doing a sort of a different shape where you might sort of connect the point that is says property line 59.48. There's a point there where you might pull that property line back, but not really a property line, pull the sidewalk line back to allow for kind of a roomier area. Your concern somehow or other is that it deprives the owner of that property. Is that what you said?
The question, the issue that comes up is currently right now, the proposed building is based on the lot area, the floor area ratio. Right. And if that becomes public space and it becomes city property, then the lot is smaller and the building needs to become smaller. I mean, it's just, that's the way it is. Sure. But the one thing that I want to point out here, though, is I think that there's some confusion here, or perhaps I'm not understanding. It's not as if that private property there that's proposed south of the building is going to be like paved area. It's still going to be a grassed area. So what we're talking about here is just a question where that's all going to be green space, and the yard, it's just that a portion of it is going to be city property and a portion of it's going to be private property, very similar to, you know, buildings all throughout the city and lots throughout all the city. So I'm just, hang on a second. I'm trying to do a quick drawing right here.
No, I'm looking at drawing 7 of 7. And I mean, I know, I think what I would be concerned about having a sidewalk that is used for public be located on the zoning lot to retain the floor area, yet it would be the responsibility of the private property owner to maintain that sidewalk. In this case,
it always is. All property owners must maintain the sidewalk in front of their properties. You get a ticket if you don't do it.
I understand it, but I think here it's more obvious where, I mean, the liability and issues become even more if you're allowing a portion of the sidewalk to be a private property that is being used as a public property, and the liability becomes greater. So and burdening a small property owner for that, I think that's a lot of ask. So I would be okay with the sidewalk remaining on the public side and not having to encroach. I get that issue and I'm okay with it. My only request is, if you look at drawing 7 of 7, where it says 35.68 sidewalk, there's a dimension. And above that, there's a little patch of green that kind of comes and terminates at a dot, which says 28.24.
Correct.
Is it possible to extend that green? You're literally actually extending it by moving the fence line a little bit back, just to keep it uniform, that's all.
I understand what you're saying, but from a practical difference, there's no change because that's all green area. It's just whether it's private property or for an individual walking down that sidewalk, they're not going to notice the difference one way or the other. So what we're doing is we're maintaining the current lines of the privately owned lot, but that's all going to be green and grass area. There's no change. So I guess I understand what you're saying, but I'm not sure what the purpose would be.
Okay, all right.
All right. I do appreciate the efforts, though. I think that's okay.
Thank you.
Thank you.
Thank you. All right. All right. Let's see. Is there anything else? Sorry, now I'm just going back. So we don't need the statement about 7201G. We have all the sign-offs, so there's nothing. Let's go to the public.
The case we are currently discussing is 2021-2A through 2021-7A Hollis Avenue, Queens, 99-21 Hollis Avenue, Queens. Should you wish to discuss, call 646-558-8656, enter webinar ID number 813-7238-1108. Press the pound sign. At the next prompt, you will only press the pound sign. Once you're in the Zoom room, press *9 to raise your hand, *6 to unmute. If you're already in the Zoom room, just raise your Zoom hand.
Okay, so let's just give a couple of. There is one caller, someone who called in, last two digits 262. If you would like to speak on this application, you raise your Zoom hand by *9. And there's only one other person so far in the Zoom room. Just to, yeah. Just to summarize, there isn't any submission due, correct, everybody? And
Excuse me, Madam Chair, Jeline, because she can't get in for some reason. Cause she said that they don't have the DOT sign off.
Oh, right.
Yeah, Kalila didn't respond to her emails yet.
Okay, right, don't have DOT. Thank you for pointing that out. So most important sign off we don't have. So even if there's lots of history to show that they don't have use for this, we rely on that agency to tell us. So if there's any way we can expedite this, I think we can. It's substantive, but at the same time, it's either a yay or a nay. So we could close, and if they say nay, then it reopens and we find out why they say nay. Okay.
Understood.
So, thank you. Thanks very much, Jeline, for noting. Okay, so I'd like to make a motion to close, but of course we need DOT.
Chair Promoter,
Aye.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta. Oh, I got it. You okay?
Yes. Voice.
Aye.
Yeah.
Commissioner Sheta,
Aye.
Commissioner Shabeta.
Aye.
Okay, thank you very much.
Thank you. Have a good afternoon.
It's before we start on the new case, it's 3:15. We've been at this for 2 hours and 15 minutes. Maybe we take a 10-minute break and come back at, what is it, 3:20, 3:20, 3:25? How about that? Okay.
Sorry, Elise. I was just throwing back. Ooh.
Okay. Everybody could return, please. I think we can start, no? Oh, where's,
Maybe we want to change the caption from review. session.
Yeah, Steve. Steve or Carlo. Thank you. Okay, we're back on the record. Appeals calendars, new item for July 18, 2022. Item number 33, 2021-57A, 1990 Highland Boulevard, Staten Island. Ms. Holdera, the only one appearing?
No, we should have a Charlene on. She was calling in before. She was probably the number you thought you saw on it.
yeah, oops.
She's the architect.
He had called in and there was also a phone number, but Charlene Huang.
Yeah, so but she said her Zoom doesn't work for voice.
Oh, so 262 is her number then. Yes. So to unmute the 262, you need to dial *9. There you go.
Okay. It's telling me I'm unmuted. Hello.
Good. Are you able to accept panelists so we can see you on the Zoom?
Oh, okay. Sure.
There you go.
Hi.
Hi.
Okay. So Elise Fullader from Eric Palatnik, PC. Charlene, do you want to introduce yourself quickly?
Hi, my name is Charlene Xiao Huang from Nix Engineering.
Okay, thank you. We're going to go through the comments one by one. We're here on behalf of the applicant, and then we will ask any questions. I might share the screen if that's okay with everyone so we can look at the plans together. Screen. Sure. Okay, everyone can see that, right?
Yes.
Or should I make it bigger? Okay, thank you very much. So the first item that we heard is about the saying it's the first floor versus saying it's the cellar, or saying the ground floor versus the cellar. And Charlene would like to ask a question about that because the building code and the zoning makes it a little bit inconsistent. So Charlene, would you like to explain why you marked it the way you did, and we can ask them how they would like us to show it?
Yes. So on the plot plan, I should have definitely marked it proposed one story above the flood elevation. But in terms of like the floor area computation and also on the floor plan, would it be acceptable if I call it kind of cellar per zoning resolution and then first floor per building code?
Oh, I see what you're saying. So the building, that's interesting. The building code hasn't caught up with the flood regulations? I'm confused.
Yeah, they always give me this objection of I need to still show it as, you know, because it's 2-story above grade. So they still want to see it first floor and second floor that way.
Mm-hmm. Okay, if you're
but
having,
I can definitely go both.
Yeah, so that's okay. You can say, you know, cellar for whatever it is, section, what is it? Vice Chair 64-332 or something like that.
Yeah, 64-322.
322 or 332?
64-322, I believe. But that's what I have it in my note.
All right. So anyway, just in case it's the wrong reference, but check section section 64 or whatever, that, and check that that's the place where the terminology is for treating it as a cellar. And you can write cellar for flood regulation purposes and first floor for building code on the drawings, just to clarify.
Okay. Okay, got it. Thank you.
And then that helps us get into the next section is she looked in where we looked together into that section 64-322 and wanted to discuss what section she used of it and why she used it, and then have a discussion. Thank you for Commissioner Chanda for pointing it out, to get clarification on how we counted floor area. So Charlene, do you want to explain what you looked at? And I can show the zoning resolution if we need to.
Sure. So it was section, let me see, 64-322 B, number 2 instead of number 1. Let me see.
So she went to C2.
So 60.
So I actually have
322. We need to get there. That's what 322. And what's the question?
Commissioner Chanda pointed out that she looked at B. She looked at.
No, I looked at
section 1. Yeah,
C.
C1, but then you did C13, right? C13. Such floor space shall be limited.
I think all of them apply. It's just I specifically read out 3 because of the accessory parking that you're proposing.
Yeah, so we're gonna just discuss, we were trying to clarify what we're supposed to do about that. And she looked at a slightly different piece of that regulation. And so I'm having her explain how she counted floor area and why she can have that accessory parking space there, or what we need to do to fix that and have it be clear. So, Charlene.
Okay, so yeah, it was under the same section 64-322. So number C, I was looking at number 2. Underneath that, it says in all districts, the floor space located below the first story above the flood elevation may be excluded from the calculation of floor area, provided that such floor area complies with the flood resistant construction standards for wet flood proof up to the flood resistant construction elevation or higher. So we are providing wet flood proofing. In my next submission, I'm going to provide a statement on the plan set that indicates this.
Okay.
And this is the section.
Yeah, so whether or not it's a cellar, it's treated as not floor area, whatever you want to call it, basically by this number 2, right?
Yep.
Maybe excluded from the calculate. Yes, it doesn't really matter whether you call it a cellar or not. It just doesn't count as floor area. So when you do your floor area calculations, that level will be exempt, will be not floor area. Right? Okay.
It's, Madam Chair, it's somewhat similar to, I think, the concept of, existing commercial buildings where the lower floor or commercial buildings with uses below grade is not counted towards floor area in the cellar, but it does get counted towards parking.
Oh, I see what you're saying. Yeah. Okay, so now your concern is about the parking question, or?
Yeah. So this is the part, it is confusing for me as I'm looking through the resolution as to whether in the situation of sites that located in flood zone, how does the parking get calculated, where if you apply that section 2, where first floor, look, I'm sorry, I've got a frog in my throat. Floor space located below the first story, does not have to be counted towards floor area, but it seems it can be used for programming purposes, but does not get counted towards floor area. How does that get counted towards parking, and is that being factored in?
Oh, I see. So,
And it's not clear through the resolution.
yeah. So they may not have actually addressed it, but for sure you're allowed to have retail below the base flood, like all of Coney Island is retail below base flood.
Right.
I don't know. Anyway, sort of like.
I think that's why it's best to have DOB review and ensure compliance, because this is, we're not granting a use or a bulk variance, it's just a GCL.
Correct. But it's an interesting question, even for city planning. Hey, did you guys leave out that part of the question? So DOB may be interpreting what they have to interpret, but city planning may not have addressed the specifics of the question. So it might be worth asking them if they did, and if they did, where is it? But not in any official resolution. That's like a side thing in a conversation that you might plan. Go ahead. Okay.
So I'm not sure. So I guess, Chase is raising his hand. I don't know if
So, hi, I just wanted to add for the board. So it just appears that on the first page of the plans there, where the first floor area diagram and second floor area diagram is versus page 4 of the PDF of the plans, it just appears that the lower level is a 1-to-1 of the upper level. Insofar as it's, whether it's floor area or floor space, it's not fully accounted for in the calculations.
Okay, so in other words, you need to indicate that it's exempt, it's the deducted floor space, like it might be in a cellar, right? Or exempt floor space, like it might be in a cellar. Is that what you mean, Chase?
Right, it on the first page of your plans, the first floor area diagram doesn't appear to accurately depict the first floor of the proposal compared to page 4 of your plans.
Oh, here?
Yeah.
Okay, Charlene, do you see that?
So the calculations based off of that small, yeah.
Yes.
Okay. So do you know what to do?
In the next, I know what to do. In the next submission, I will, show the entire first floor, but then to show the deduction.
Yes. Yes, exactly.
Okay. So I'll go to the next, if we're good on that, I'll go to the next discussion. So we submitted a BPP with the curb cuts, but we'll put that more clearly on the plans and not just have it on the BPP. And then kind of a comment that went in line with that comment is about confusion about how to get in and out of the parking space. So Charlene, would you like to discuss where the curb cuts are and how the parking space works? I'll go to the parking. It's clearly.
Yeah, it's possible to pull up the builder's payment plan.
Do you want me to pull up the builder's payment plan?
Yeah, like the first page, if we zoom into the park plan.
Is that good? Do you see that?
So I have the two.
Sorry, when was the BPP submitted? What's the date?
4/22.
BPP.
4/22/2022.
Oh, I see it. Okay, it's spelled out. Always look for BPP. Okay, thank you. Go ahead.
So on the BPP on this plot plan, I have it. I have the two curb cuts shown on this plot plan. I will show the same information on the other plan set. So basically, there was one curb cut that allows the vehicle to drive into the building, and the other one is for them to exit out of the building.
But it's so close to the intersection. Is that really allowed? That's that one that's close to the intersection. It's super close. Does this comply with DOT requirements? Because you're already, I don't know.
Yeah, so we made a submission to the DOT. We're still addressing their comments.
Charlene, you could always, if you want to look into how it complies, if you need, Commissioner.
I have a question. Why not reorient the parking spot and only have one curb cut? Just rotate it by 90 degrees so it's perpendicular to Jefferson Avenue and just have one curb cut. Car goes in, comes out, just like residential.
The same ones that pull in and out?
Yes.
Yeah, I don't see how they're gonna let you have that second curb cut.
Yeah, I echo Commissioner Otley Brown's comments. I do not see just for one car to have to provide two curb cuts. You could use that curb cut that is furthest away from the intersection of Highland Boulevard and Jefferson, and have it's like you drive in and then maybe make a U-turn within the building and then you drive out rather than having to reverse. So
yeah, that's a very good suggestion. We had it that way. The way we had it is because in the beginning we tried to set 2 spaces in there, but then it just wasn't enough room to maneuver. So now that we are down to 1 parking spaces, but yeah,
I mean that is assuming DOB's interpretation. That is assuming DOB's interpretation of the parking regulation in a flood zone. It would result in 1 parking space and not require parking based on the floor area used in the cellar also. That part I'm not sure.
Yeah, we will double check. We will double check that.
Okay, so we'll look into that and see what we can do. And then the next question, sorry, I have to go back to my notes. The survey BPP was in NADV 88, and we can clarify that on the plans, but I think there was also confusion. But I guess if we fix our curb cut issue, there might clarify the confusion about this, right? And where the curb cuts in and how you enter the doors. I remember a comment about.
Right. So basically, looking at the elevation along Jefferson, the front elevation along Jefferson, the elevation at the bottom of the page.
Right.
So the window and the opening at the first story of the building will likely, like the one in the middle, will likely be eliminated.
Oh.
When you say first story, are you talking with the building code first story?
Grade. You could just say grade.
Yeah.
Oh, okay.
Grade. So you're going to eliminate the opening in the middle at grade?
Yes.
So, okay.
So depending on what we decide with the parking space, we may either eliminate the other one, or we may combine into a bigger opening, depending on what we decide on the parking.
Because I don't understand how you could use the one on the far left if you eliminate the curb cut. It's probably not allowed anyway. So I have an aesthetic question on your facade, which may just be the computer doing its thing when you print it. You have this arched window over your garage door. Is there a reason it doesn't line up?
It's not. Yeah, it's supposed to be lined up. Yes.
Yeah.
I have to put on that.
Okay. I know that's a little CAD program where you just slide it along and then it wants to snap back to where you didn't want to put it. But yeah, okay.
Yeah.
Okay.
It's definitely meant to be that. Yes.
Right, okay.
Okay, and then in terms of the use that's going in there, we don't have a tenant yet, but I can come back and ask the owner one more time if he has a proposed tenant or any interest in someone there. But it would be a use group 6 commercial tenant.
But so then that's why it's even more confusing. If this is use group 6, then why do you need these I get maybe why you'd want one curb cut for an on-site parking, but by having the parking space at the back, you're creating all this relation where you'd really want that to be arguably retail space, right? Circulation for the car, right?
Okay, yeah. So I guess that's something we have to talk about. Charlene, you understand, right? We'll talk about that offline.
I mean, you would think you just drive in straight and your car's parked, straight in, car's parked, and all the rest is retail space with store. Right. Okay. But again, we don't need to design your unit or your building or whatever. The curb cuts are relevant in this situation, but the what goes on inside isn't. Okay.
Yeah, and then I think we covered all the questions, at least I understood, unless let me know if I'm missing anything or there's any page you want to look at more closely.
I had a question regarding the method of flood proofing. You would put a note in the plan, right? I think that's what I heard you state that.
Yes.
Okay.
I just had a question with regard to if you already acquired a tenant for this location.
No, we don't believe we have. I'm going to check back in. The owner's on vacation, but I'll check back in with him if he has any interest in tenant or if there's any interest from a tenant.
Okay. Okay, let's go to the public.
Stop sharing.
So the case we're currently discussing is 2021-57A, 1990 Holland Boulevard, Staten Island. Should you wish to call in, the dial-in number is 646-558-8656, and to webinar ID number 813-7238-1108, and press the pound sign. At the next prompt, you will only press the pound sign. Once you're in the Zoom room, press *9 to raise your hand, *6 to unmute so that you can speak. If you're already in the Zoom room, please raise your Zoom hand.
Okay. So, how much time? Do you have any other? Are there any other questions from commissioners or from Ms. Huang? No. Okay. So, how much time do you need to make these changes?
Charlene, how much time do you think you need to look at the parking and a little bit of a redesign and answer DOT?
The DOT, do we need to get the approval and then come back, or?
Yes.
But we work with the BSA helps us, so we respond to the DOT through the BSA. We don't just do it like on our own and come back here. They like help push us, right?
Yes.
Yeah.
Okay. I would say 3-4 weeks.
Okay. Is you sure that's enough?
That's for us to respond, right?
Yes.
Charlene?
Yes, for us to respond, yes.
Yeah. And then however much time DOT needs to review that.
Okay. All right. So I'll just make a note then. 1 month to submit plus DOT review, right?
Mm-hmm.
Okay. I don't see anybody calling in. Let me just make sure. Sorry. Okay. So then that's what we'll do. So 1 month to submit, and that's probably therefore not something around October.
Mm-hmm. Sounds
okay.
good. Mm-hmm.
All right. So that's that. Thank you so much.
Thank you.
Okay.
Thank you so much.
Thank you. So as we said earlier today, 2022-2A, 728 Court Street, Brooklyn was postponed for another date. which we will reach out to people and let them know. So therefore, that completes the public hearing for July 18, 2022.
Thank you, everyone.